From distant lands we gather, hearts of fire all along. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. Warriors of the ancient sea, songs of glory dark and bold. In the night, our spirits free, legends born, tales unfold. Oh, big because we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight. From horizons wild we roam, with thunder in our soul. Every battle brings us home to the stories ages told. Oh, big Nick, cause we follow through the storm and through the fight. For Valhalla we will borrow strength and might under moonlight.
Heyo, folks, it is Friday, and I didn't know if I were going to have a panel show, so I haven't actually invited anybody. So, yeah, I was home from work just around 7 p.m. and I started 6 a.m. So a long day. And then I had a really great nap. I had bangers and mash and a hint of whiskey, and everything was all right again. So I decided, yeah, I think I have a Friday stream. I think I have a Friday stream in me. Yeah. Let's see who's here. I see Ambrosia over at Rumble. Hey, Ambrosia. Good to see you. Over here at YouTube, let's see who has shown up. First was Lokong Express with mailboxes. SB. Ho. Hello. Kelly. Also, and hey, Vice Baby, Josh Mo, American Dreamer, Sweet Fly on Wall, and a bunch more. Good to have you here. T42 is lurking. I'm perfectly fine if you're lurking as long as you hit the thumbs up. Yeah, you know the drill. You know the drill. Oh. All right. Okay. Now, I have two subjects I want to talk to you about today. It is Delphi. I saw a really good post by Catastrophe on X, and which I need to go through with you. And then we have YNW Melly, a second motion for pre-trial release following mistrial. So those are the two things. Now, if you have other subjects you want me to, hey, what about this? Because I don't know how long I will go on. And I don't want to run out of subjects. And now, what whiskey am I drinking? Well, whiskey is in the jug, because me likes jugs, but it is, I poured over this Ven Old Hair. It is a Swedish blended whiskey, which is my go-to whiskey. And Kelly, thank you so much. Cheers to Friday. Yay! Cheers to Friday. Cheers to Friday. And so yeah. And hello. Yeah, so I'm streaming on X, YouTube, and Rumble today. It's the usual things. Now I'm starting later than usual, and I started with very short notice. I have no idea how many people will show up, but if you want to help me with that, thumbs up, share if you have social media. I'm on X and stuff like that, and let's get some people in here. All right. Well, I'm going to start with this Delphi thing. Let's see here. Dun dun dun. This is from Catastrophe. It's after 4:30 p.m. in Arizona, daylight saving time. Yeah, it is midnight over here. Why is this so small? Can I do this? No. Can I do this? No. Can I do... A little bit larger. No, you will never escape Delphi. This is a Catastrophe, who is talking about Delphi exhibits and writes, in anticipation of any of these reasons being proffered to justify withholding Rick Allen's exhibits, her response to McLeland's motion to seal and keep confidential crime scene photos and autopsy photos. And 1 and 2. Indiana's coroner statute does in fact exempt the photographs, video recordings, or an audio recording of an autopsy from public access of a death that is being investigated as a crime. Unlike law enforcement agencies or the court, the coroner's statute is ratified by the first prong and need not be found arbitrary or capricious. However, this is not absolute, as the victim's next of kin are largely in control of the public access of all the finding. So yeah, because we have heard this a bunch of time from the prosecution in the Delphi case, that these should never be public. Well, that's the standard. Now, we know there has been leaks in the past. And I'm not talking about the burglary at the defense attorney's office. I'm talking about prior to that. There were a leak of crime scene photos prior to that. So this is just the prosecution in this case playing nice guy. Oh, you should never. Well, first of all, you probably did. And second, the standard is no, it's not going to be public. George Moore says, fun fact, coroners in Indiana do not have any qualification as medical examiner. That's why the girls' bodies were sent down to Terre Haute to be examined by a real certified ME. Yeah, I know, medical examiners, and this is in many places where some medical examiners, especially the head of medical examiner's office, is elected. So any fucktwat who wins an election can be chief medical examiner in many states, which it's just plain stupid. Let's see here. This 514.34b does not hold that any investigatory records of law enforcement agencies as it pertains to victims who are juveniles is except from public access unless and to the extent that the parent, guardian, or custodian of the victim consents in writing to public disclosure of the records. While 514.34 asserts that the release of investigatory records of law enforcement agencies are at the discretion of the agency, B applies to juveniles, granting guardian discretion. However, B applies to living juveniles that are perpetrators of crimes. The state's contention that this applies to non-living juveniles is grossly misplaced and inapplicable. Yeah, another good counter argument, because folks, we are almost 5 months since the trial, and we still barely have anything of the evidence in the trial to go by. Yeah, Bosch, it isn't applicable. George Moses, the active investigation exception to these disclosure laws is very broad in Indiana. Nick McLeland and the FBI have reacted his FOIA request multiple times due to active investigation exemptions. Yeah, it seems like they are keeping the investigation open in order to not release the trial evidence. So do they believe that they have their... Well, it's one of two things here. It is either they don't believe it was one perpetrator, or two, they don't care. They have somebody convicted and they're waiting for all of this to die out. Hello, Mr. Jingles. They're waiting for our coverage to die out. And then they might ease up on it. Or maybe if when McLeland disappears from office, maybe the next one has ethics, has some kind of morals, isn't a cunt. Yeah, I'm going for a non-monetized stream. Sorry, if you're easily offended by words, today is not the day. Let's check the next one. 4. That the defense has already negligently released crime scene photos that have caused irreparable harm to the victims' families is an assumption yet to be actually proven with an actual investigation. The investigation listed Andrew Baldwin as being victim of a crime, and unless this was foreseeable, as with an area known for violent crime, there has been no liability, and the contempt proceedings, if anything, show the public evidence that the state is just as likely to be responsible for the release of crime scene pictures and quote-unquote protected information long before Rick Allen was even arrested. The public has yet to hear from Mitch Westerman. I agree. As you might know, that Baldwin, his office, was burglarized by a former associate who SB, I was writing hope, but the P disappeared. I'm so sorry for calling you a hoe. I'm so sorry. Oh. Oh. Yeah. And let's go back to this. And crime scene photos was already in circulation before. And if you are in some way, shape, or form, if you are conspiratorial, somebody was trying to set Baldwin up. Oh, it's getting worse and worse. Let's see here. We're there. Let's check here. 5. That release of the autopsy photos would have had the same effect on the victims' families and would re-traumatize them for years to come. What is the same effect on the victims' families? The families have already been exposed to all of this information, and if Abby and Libby really solved their own murders, and Libby wanted to be a crime scene investigator, it would not be far-fetched to consider Libby might want to be of investigatory value in death and perhaps assist in investigating the deaths of others. However, this paragraph is unnecessary and only contained to inflame the reader, for paragraph 2 has already covered this issue related to autopsy photographs. Yeah, this is stuff that the prosecution has hinted on, or in some cases said out loud. 6. The request that any medical, mental health, or records related to the mental health and medical health care provided to Rick Allen from the Department of Corrections and any other agency be sealed pursuant to blah 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 is vague and partially moot due to the publication of such written medical records to the media during Rick Allen's trial. And here you have patient medical records and charts created by a provider unless the patient gives written consent under IC 16-39 or as provided under 1641-8. And those are insanely broad. Insanely broad. Hey! Dave says, just bury this in a coffee can for me and I'll be there soon to receive it. Yeah, sure. Thank you for $20. Thank you so much. Now, this is also in anticipation of why the state want to keep all of this hidden. Now, we already know these things, but we don't know all of the things. That's the issue here, which the prosecution and the investigators probably do not want to be public. All we have is the cherry-picked things. Now, thanks to the defense, we know more, but we don't know all of it. And that is a huge problem for me, because in order to, if you really are this convinced of a person's guilt, you are not scared of the information in the investigation. But it seems like that is all both the prosecution, Judge Gull, and the investigators are. They are scared shitless of what's in there and what we will do when we find out, and what the judicial will do once everything is actually out there. They are scared shitless. Chapter A, confidentiality applies to prosecution related to the offense of transmitting a deadly disease. If the state wishes to make confidential the medical and mental health records of Richard Allen, I ask the state to cite to specific codes within the above-mentioned statutes and specifically identify each record that the state is in possession of and attempting to transfer. Quote, any other agency is extremely vague. This petitioner would argue it is akin to the defense's request to this court to preserve, quote-unquote, any and all evidence, which failed for exactly the reason the states prevailed. Yeah, remember that? The defense wanted any and all evidence preserved, and Judge Gull denied it. So we might be in a situation where we will never find out. Never. George Moses, there was a recent unaliving in South Indiana, Clark County, on Valentine's Day. Oh, husband versus cheating wife. For the ME report plus interview vids, it was rejected due to the active investigation exception. Yeah, if it happened on Valentine's Day, then the investigation is probably still open. Let's see here. 7. This is a long one. The courts are permitted to seal public records introduced at trial when, upon introduction, a party requesting such record be admitted under seal. the failure to do so at the time the item is admitted into evidence is considered a waiver of that party's right to seal public exhibits in the record. While the state is correct that courts are permitted to seal public records that fall within the mandatory exception to Indiana Access to Public Records Act, without conducting a hearing, the state's conclusory statement is vague and misleading, as not all of the items in the state's motion can be sealed this way. McClellan correctly states that the courts are permitted to seal public records that fall within a mandatory exception to Indiana Access to Public Records Act without conducting a hearing required by IC 514.355 before or after records are admitted into evidence. However, once again, the state would like to have it both ways, in addition to misleading the court and the public. The only portions of the record that can be sealed prior to their admission into evidence or retroactively without hearing are the few access to court records exceptions which would not require a hearing to be made confidential at any stage of litigation. Yeah. So if the state says, nah, it's sealed retroactively, that is extremely narrow. What and when they are allowed to do that. Indiana Code 514.3.5. Before a court may seal a public record not declared confidential under Section 4A of this chapter, it must hold a hearing at a date and time established by the court. Notice of the hearing shall be posted at a place designated for posting notices in the courthouse. Joe Schmo says, other states send out videos all the time for cases that haven't gone to trial. Mickey Steins and Sarah Boone. Yeah. The petitioner requests the state to identify which exhibits or which portions of the record apply to which subsections of the statutes. Further, unless an entire exhibit or document is confidential, there must be a public redacted version and a confidential version attached with appropriately filed out ACR form. For example, an entire document cannot be excluded just because a social security number or address is listed. Those items must be redacted. For example, exempt from disclosure in part are the following: a photograph, a video recording, or an audio recording of an autopsy. Photographs, video recordings, or an audio recording of an autopsy are exempt from public access and may not be disclosed. Is incorrect. Public disclosure is largely in the hands of next of kin, children of victim first. If any, then it would fall to the parents of the victim. These records would be exempt from public access unless and to the extent that the next of kin of the victim consents in writing. And then this again is Catastrophe. Go follow her on X. Further, it may be argued that Prosecutor McClellan's public attachment of crime scene photographs to his own post-trial motion, in direct violation of this court's order, constitutes a waiver of any right to seal all crime scene photographs, which again is another overly broad request that managed to survive this court's especially stringent standard of specificity that has seemingly only been grounds for adverse rulings applicable to request by defense counsel. And then she signs, I'm not a lawyer, I did the research. So they are sealing records. Is that what I'm hearing? This is catastrophes in anticipation of any of these reasons being proffered to justify keep withholding the exhibits in the Delphi trial. So it is speculation regarding what will the state use as arguments. And I think she is spot on here, because these are the things that the state has been alluded, hinting on throughout the case. Seal everything, do not disclose anything, nothing should be public. And again, we are more than 5 months after sentencing, and all we have is the 43-second video. That's it. Other than the Frank's memo and stuff like that. And remember, Judge Gull has claimed that if you send in $25, we will send you a 125 gigabyte thumb drive. This is months ago. Not one thumb drive with evidence have been sent out. Not one. So this is the court and the prosecution. They don't want us to know. They simply do not want us to know, because they know the collective knowledge, the collective investigatory capability of the Free Rick Allen movement, if you please, will find every lie. Everything. We will find every discrepancy, every lie, every shadiness, every piece of corruption. We will find it. And they are scared shitless. It's simply that easy, in my opinion. Folks, remember, all the way up until the release of the 43-second video, you had Holman, you had McLeland out and about in press, on YouTubers, and saying, don't do this, let it go, let it go. Once the 43-second video was released, silence. That was their crisis management, gaslighting. Go away, there's nothing to see here, look the other way. And we won't. We won't. First Best GD, do y'all think this case got more national attention than Judge Gould was expecting? Definitely. I suspect that Judge Gould, this is how she works. This is how she acts. And she's been doing it for decades undisturbed. But then this case came along. And she handled it as she normally does, by not caring and keep going. Now, the prosecution tried and failed. And the more information that was given through different documentation, through motions, through filings, through the Frank's memo, and then people who attended the trial. And even then, Judge Gull tried to more or less throw people out without throwing them out, limiting the amount of seats to the extent that not even Rick's family, some people of Rick's family could not be in court, even though there were plenty of seats. Judge Gull, go fuck yourself. Hey, Gwendolyn is here. Gwendolyn is here. Let's see what else about. Let's see here. Dun, dun, dun. Now, that's about it for now, at least, about the Delphi. I thought this was an excellent way to get ahead of the prosecution, because we know they will still try to hide things, and they are. Let's be honest, they are successful in hiding stuff. As I said, 5 months since sentencing, and we still only have the 43-second video. And I can bet you good money that they are furious that this came out, because it showed us that the prosecution has been lying. The investigators have been lying to the public since more or less the day they found the girls. And now, it's not unusual for cops to lie. They went out and about the sketches. They put up one, then they never didn't search for that one, and then they put out another, and everything was meshed together. And then they published just a few seconds of the 33-second video, and then they meshed that together to make it at least it seemed like he walked. And then they added the down the hill. And when it comes to people who are used to lying, is that they can't stop lying. It's second nature for them. So even if they thought this would help them draw the suspect out or draw the killers out, it wasn't successful. But they couldn't stop lying, so they kept lying and lying and lying. They really. Auto Doctor, what was on the ring activity log that Proctor had to hide? We are not talking about the that case. We are not in the Karen Reed case. We are in the Delphi case. So I don't know what that is. Nom. I almost forgot. Let's see here if I have this. Yeah. One thing. Remember Kathy Shanks, how she cleared Ron Logan? I want you to think back what they knew when she cleared him. They knew that the girls was found on his property. They knew he lied about his alibi. They knew that his phone puts him outside of his home close to the time the bridge guy video was recorded. They knew he confessed twice to a fellow inmate. And they knew that his gun could not be excluded for the cartridge found between the girls. Now, for me, the cartridge has nothing to do with any of this. But that was what the Kathy Shanks recommended to the investigators to clear Ron Logan. Now go a few months later. What was the one thing they had on Rick Allen? He was on the other side of the bridge and he saw 3 girls. That's it, folks. That is the only thing that Kathy Shanks saw in that tip records. That's it. The rest in the affidavit and everything else was made up. Everything. Forget everything we claim we know now. What did they have on Rick Allen? He was on the other side of the bridge and he saw 3 girls. He watched some fish. He went home. That's it. And you might say, yeah, but they have to check. Yeah, but remember here, they cleared Ron Logan, who lied about his alibi, confessed to a fellow inmate. His phone put him outside of his home at the time the bridge guy video was recorded. They were found on his property. All of that they knew. So if you compare the two, who would you investigate further? Am I convinced Ron Logan is the actual killer? No. Do I believe he had something to do with it? Abso-fucking-lutely. Abso-fucking-lutely. And this is also, why the fuck is Kathy Shanks, without any law enforcement training, the one who decides who is cleared or not, or recommends to the investigators? Is it because her family is generations of Freemasons? I don't know. But it sure as hell looks very suspicious, doesn't it? That a prominent Delphi Freemason family shows up as a volunteer in the local precinct and starts telling people who to investigate or not. And let's go back to the Flora 4. The prime suspect is a Freemason. And he is still at large. What am I drinking? I am drinking this Old Hair. It's almost empty. Yeah, it is because I poured it over into this because I like jugs. Auto Doctor. I think most people, including law enforcement, just saw the image of Bridge guy and imagined Rick Allen and him, and that was it. Yeah. Despite Rick Allen working at CVS, looking, everybody was in there. They saw him day out, day in, day out. And not one looked at the sketches and thought, hey, that looks like Rick Allen. Down the hill, they spoke to Rick Allen 5 years, and not one said, hey, that sounds like Rick Allen. Not one. Old Hair, that's a Ven, isn't it? Yes, it is. It is a Swedish blended whiskey, and it's very, very nice. Oh, yeah. Oh, I almost missed that one. Where did it go? If they ruled out Klein, how did they do it? Why can't they tell us? Great question, Auto Doctor. Keegan Klein, who told one of the girls, be at the bridge. A guy who was caught not in 2017, not in 2018, not in 2019, in 2020, 3 years later. Then, in a separate investigation, they caught him with 350,000 images and videos of minors. 350,000. Through his aliases online, he had been grooming dozens of minor girls. How the fuck do you clear that guy? Well, I will tell you. Because Holman, the human lie detector, decided he's not credible. It's not him. Well, if you know he's lying, then you have to go back to what do we actually know that he can't lie about? His whereabouts. What is he actually capable of? There are, in my opinion, Keegan Klein, Ron Logan, and I almost said Logan Paul, but not this time it's not his fault. Brad Holder are my prime suspects. Patrick Westfall, yeah, in the vicinity. Yeah. Because had they actually investigated what are the connections between these guys, they might have found something, but they never did. They never did. And I find that so infuriating that we can sit here as bystander and scream from the rooftop for years. How can you not look at this? And is it incompetence? Yeah, maybe. But I mean, we've all seen cases with the same or even less evidence where they actually investigate. But it seems like in this Delphi community, 3,000 people in Delphi, in the village of Delphi, Indiana, everybody knows everybody, and everybody who is something is a Freemason. Now, does that mean that the Freemasons, hey, go kill those girls? No. It means that you give your fellow Freemasons the benefit of the doubt. And who was not a Freemason? Rick Allen. An outsider. They moved into Delphi, the Allen family. Outsiders. Just like the Flora 4. And outsiders, they don't trust outsiders. But they trust the people in Delphi. There are 6 dead minor girls in the just a few months apart. And in my opinion, 6 dead minor girls, it's unsolved. And probably the reason why it's unsolved is because the perpetrator is from Delphi, Indiana. Probably a Freemason, because they are given the benefit of the doubt. And I don't know what to say more than I wish we had more information. But then we go back to the situation we are in. We don't know because they refuse to release the information. So what else can we do but to take the information we have and go with it? Because we can't really afford to forget, to slow down. Now, the Delphi case has slowed down. It's the nature of it. People will move on. There will be a new trial. I have a harder time with that. That is why you keep hearing me 2 years later about the Zachariah Anderson case. I can't let go. Cheers for not letting go. Hey, Justin. Good to see you. Let's see here. What kind of ancient magic engine Delphi where blood cults are real and the Freemasons are what all the conspiracy theories think they are? Yeah. It's bias is what it is. People give each other the benefit of the doubt to something that an outsider an outsider would not be given the benefit of the doubt in Delphi, Indiana. And we know that because they charged Rick Allen with absolutely nothing. They embellished and lied in the affidavits to get a search warrant. They hired a toolmark expert to, in my opinion, lie for them. And now Rick Allen is in prison for 130 years. It's infuriating. It's simply infuriating. But that is the obligatory Delphi case segment. You will hear more about it. You will hear more about it on this channel because I will not let go. But let's talk YNW Melly. All right. YNW Melly has, through Attorney Raven Liberty, filed a second motion for pre-trial release following mistrial. And the mistrial they are talking about is, of course, because we are up towards the second trial now. Let's see. Boom. So they are arguing that they should let him go. Defendant Jamel Demon's second motion for pre-trial release following mistrial. The defendant, Jamel Demons, buying through the undersigned counsel pursuant to Florida Rules of Criminal Procedure 3.131 and Article 1, Section 14 of the Florida Constitution, and respectively moves this honorable court to set a bond in the above styled cause. As grounds, therefore, the defendant states as follows. Background. Mr. Demons voluntarily surrendered on February 13th, 2019, resulting from a grand jury indictment charging Mr. Demons with 2 counts of homicide in the first degree. Yeah, so 6 years, 1 month, and 10 days ago. A written demand for a speedy trial was made on May 26, 2022, and the jury selection was to begin in the middle of July 2022. However, trial did not occur as demanded due to the state appealing an order of the court striking the state's request for imposition of the death penalty upon conviction. The 4th District Court of Appeal reversed the trial court's decision. The Supreme Court of Florida subsequently denied jurisdiction. On April 6, 2023, the undersigned filed a notice of expiration of speedy demand. A hearing was held April 11th, and the jury selection began hours later. Opening arguments were given on June 14th, 2023. Trial testimony included testimony from various law enforcement, included but not limited to Detective Mark Moretti and Detective Danny Polo. On July 22nd, 2023, Judge Murphy declared a mistrial when the death-qualified jury was unable to reach unanimous verdict as to Mr. Demon's guilt on all counts and set the retrial to begin on October 2nd, 2023. That's a year and a half ago. On October 12th, 2023, the then lead prosecutor, Christine Bradley, was removed after the defense team learned of an all-office conspiracy to withhold Brady evidence. Detective Mark Moretti asking another officer to lie on his behalf. As a result, 3 new prosecutors took over the matter. The court granted the state's request to extend speedy trial due to extraordinary circumstances of the prior prosecutor being removed from the case and the need for added time in order to be prepared. For me, this is bullshit. Why should the defendant suffer because the state fucked up? Why? And it doesn't really matter if you believe he's guilty or not, Mr. Demons. The state still has to follow the fucking law. And if they are unable to, then throw it out. Hold them accountable. The parties began selecting the jury on or about October 25th, 2023. Jury selection was only set on the days that ASA Bucklew was available. The bifurcated process of jury selection was not successful due to the parties sometimes only convening once a week. On or about December 14th, 2023, the state gave notice of their intention to introduce the entirety of Mr. Demon's music catalog and hundreds of hours of jail phone calls of other inmates, along with 2 YouTube videos of 1099 Jake. See here, jail phone calls of other inmates, meaning it wasn't even Melly who made the jail phone calls. It's insanity. Absolute insanity. On December 20th, 2023, based on the prospective introduction of new evidence while selecting the jury, Mr. Demon's detriment, it was decided that the entire jury panel would be struck. The defense team was forced to withdraw the speedy demand in the homicide matter and seek a continuance of the retrial. Yeah, so the state fucks up and the defense has to suffer. That's Florida for you. That's Florida for you. It was agreed that the parties would begin selecting a jury beginning January 2024. It has now been discovered in the midst of all the delay tactics by the state's attorney's office. On December 13th, 2023, a warrant was issued by Judge Peter Holden pertaining to multiple telephone numbers of the undersigned, including cell phones and office landlines, searching for information regarding Danny Polo and a YouTube content creator who goes by the moniker 1099 Jake. If you don't know who is Danny Polo, Danny Polo is the guy in the balaclava, in the ski mask, who testified in the ski mask because he claimed he needed it, and he claimed that there were no pictures of him online. That turned out to be a lie, which meant that because somebody sent the defense, hey, found him, and they objected to him testifying in the balaclava, and he had to continue testifying without one. That the prosecution in this case says that is witness tampering. That they found him, the pictures of him online. They found out he lied. And for that, the prosecution started an investigation of witness tampering and got all of attorney Raven Liberty's iPhone data. Her phone, the iCloud, her laptop, everything. Everything was handed over. And they didn't find out until much later that. So this was a secret investigation by the prosecution. On January 30th, 2024, the state of Florida appealed certain orders suppressing evidence regarding emails, social media, and text messages that were prior to the date of the alleged offense, to wit, October 26, 2018. In addition, the last portion of the promotional video was found to be irrelevant and excluded from evidence. On January 29th, 2024, the court entered an order staying the homicide retrial. On July 15, 2024, an order was entering stating Mr. Demons was in custody for 1,977 days, and his retrial was set for September 10th, 2025. Upon information and belief, it is very unlikely that this matter will be ready to go to trial September 10th, 2025. The defendant has remained incarcerated more than 2,000 days since the date he voluntarily turned himself into law enforcement 6 long years ago. Mr. Demons has, for several years, been the subject of extreme mental abuse at the hands of Broward Sheriff's Office. He has not had any contact with the outside world in 3 years. Mr. Demons remains to this day a lucrative recording artist with streams of incomes. He cannot contact his managers or accountants. As a result, he has lost any control over anything he has. Mr. Demons is not allowed to talk to his younger brother or sister. Mr. Demons has protected and supported both of his siblings throughout their entire lives, but he has improperly not been permitted to speak with them because the Broward Sheriff's Office won't allow him to have any contact with his siblings, not to mention his mother, his grandmother, grandfather, great-grandmother, and friends. Mr. Demons is not allowed to speak to other inmates in the jail, and over a year ago, a sheet was put over his cell door so no other inmates can look at him when they walk by. This is isolation. This is torture. For you, sheriffs of Broward County, this will be your judgment. If you or any of you are Christians, this will be your afterlife. Having litigated several motions in trial court, as well as emergency writs in this honorable court, and having exercised his right to a trial by jury, Mr. Demons continues to defend his constitutional rights to justice and liberty. Argument. The purpose of bail is not to punish an accused, nor to detain an accused in custody prior to disposition of the case. The purpose of bail, commensurate with the presumption of innocence, is to ensure an accused appearance in court. The constitutional right to pretrial release guaranteed to a person charged with a capital offense or an offense punished by life imprisonment has long been governed by the well-established precedent of the Florida Supreme Court in State v. Arthur. As recently explained by the 3rd District Court of Appeal in Thortman v. Jr., by way of background, the Florida Constitution gives a person arrested for a crime the right to pre-trial release on reasonable conditions such as bond, subject to certain exceptions. The quote-unquote capital or life offense exception applies when the person is charged with a crime punishable by capital punishment or life imprisonment and the state can demonstrate the proof of guilt is evident or the presumption is great. A person held under this exception is entitled to an adversarial, evidentiary bond hearing that examines the state's evidence to determine if it rises to the level of quote-unquote proof evident, presumption great. Accordingly, a defendant charged with a capital crime, such as Mr. Demons, is entitled to an evidentiary bond hearing at which the sufficiency of the state's evidence may be challenged, and evidence pertaining to his guilt may be presented. See Bracket v. State. Granting the petition for writ of habeas corpus and directing the trial court to hold a new bond hearing, quote, where it shall afford petitioner an opportunity to present witnesses pertaining to all aspects of the bond issue, including whether his guilt is evident or the presumption is great. The long-standing precedent on this issue recognizes that the requisite degree of proof at an Arthur hearing is higher than that of the degree of proof necessary to sustain a conviction at trial, which the state was unable to secure in this case. The State ex relevant egen v. Williams. The degree of proof sufficient to deny an accused the right to bail in a capital case under the Constitution is actually a greater degree of proof than that which is required to establish guilt, merely to the exclusion of reasonable doubt. However, even if the state was to meet its odious burden of proving that the proof of guilt is evident and the presumption is great, the trial court is not precluded by this determination from ordering the release of Mr. Demons upon reasonable conditions. Rather, the trial court still has the discretion to grant or deny bail. See Arthur blah blah blah. If, after considering the defendant's responsive showing, the court finds that the proof is evident or the presumption great, the court then has the discretion to grant or deny bail. Is Sheriff Grady Judd in Broward County? I don't know. I really don't know. The burden is on the accused to demonstrate that release on bail is appropriate, which is to merely establish that even if Mr. Demons has no constitutional right to pre-trial release on reasonable conditions, the defendant still has the option to provide proving certain facts that permit the circuit court to use its discretion to grant pre-trial release under sufficient conditions. West FSA Constitution. Blah, 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 blah. If, after considering the defendant's responsive showing, the court finds that the proof is evident or the presumption great, the court then has the discretion to grant or deny bail. The circuit court may exercise discretion to grant pre-trial release if the defendants can prove that conditions of release can effectively 1. Protect the public from the risk of physical harm. 2. Assure his presence at trial. And 3. Assure the integrity of the judicial process. Appropriateness analysis. Nom, 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 nom. It is not permissible to continue to deny Mr. Demons the fundamental right to liberty when other alternatives exist to satisfy any compelling state interest. Mr. Demons voluntarily surrendered as requested on February 13th, 2019. He survived the global event in Broward County Jail to finally go to trial. A mistrial was granted that July, with genuine hopes and a speedy trial demand to start a retrial in October of 2023. That date did not occur through no fault of his own. The lead prosecutor, Christine Bradley, withheld evidence of the lead detective Mark Moretti during the first trial, causing the date to be reset. This misconduct led to Ms. Bradley being removed from further involvement in the case and 3 new prosecutors assigned. There appears to be no end in sight for Mr. Demons. This case has been stayed for more than a year, while the defendant has remained held in unduly strict custody, being abused at the hands of Broward Sheriff's Office and denied access of both the undersigned and his investigator. Corn Pope, I agree. I watched the trial too. They have some serious evidence, which for me is, why did they have to cheat? Why all the misconduct? There was really no need for it. But now you have an officer who asked another officer to lie for him and a prosecutor that withheld that from the defense. That, again, at that point, it should not matter if you believe he's guilty or not. If the misconduct from the state is that severe, it should be thrown out. And it will not be the fault of the defense. You should all blame the prosecution, not Melly. Bum, bum, bum. Moreover, there are multiple other motions that still need to be heard. However, if the state takes an appeal every time they are not successful, as they have done on multiple occasions in the past, then Mr. Demons will sit in jail for an unknown period of time before the case can possibly be tried. Mr. Demons is being forced to choose between a fair trial or a speedy trial. Not only has the amount of time Mr. Demons been in Broward County Jail awaiting trial unconstitutional, but coupled with the mental abuse and deprivation of basic human rights, the entirety of the situation is an embarrassment and horrible reflection of the entire legal system and the state of Florida. At this very time, BSO has placed a sheet to cover Mr. Demons' cell so no other inmate can contact him. This abuse has gone on for over 3 years, and when any attempts are made to rectify the deprivation of rights, the defense is always met with there is a quote-unquote investigation. There is no reason to believe that defendant poses a danger to the community or a risk of flight in this case. As such, there is a presumption in favor that the defendant should be released on his own recognizance without the need to post any financial bond. To that end, certain conditions can be set by this court to ensure defendant's appearance at any required court dates and to ensure the safety of the community. Wherefore, defendant Jamel Demons respectfully requests that this court grant the instant motion and order defendant released on his own recognizance. Law Office of Raven Liberty, PA. Now, to be honest, will this happen? No. And the courts have little to no power over how Broward County Sheriff's Office handle their inmates or pre-trial inmates. Yeah, I actually hung out with Jeff during that first trial on a few occasions. I actually did. And that is also why I'm doing the coverage of the YNW Melly trial. Jeff, miss you. Oh, Fedorowski, have you tried the Blendande bottle, which is blend from Van and Smögen? I have not. I can't get old hair, so I might try it. This bottle has 55.5% mix of smoky whiskies from bourbon and sherry barrels. That sounds amazing. Yeah, as Gigi says, the judge can give him a bond. Yeah, they can give him a bond on a few $1 million or many millions of dollars with more or less you're on house arrest, you can't leave your house, you have to pay for guards, you will have damn well ankle monitors on both your legs, both your wrists and around your wiener. I mean, they can impose so many restrictions. So many restrictions. Because again, it doesn't matter if Mr. Demons is guilty or not, or if you believe he did it or not. Are you okay with how the state handled this? Are you okay with a person who is presumed innocent not being able or denied contact with his mother, with his siblings, with his grandmother and grandfather? Are you really okay with a person being in total isolation? The only people he is allowed to meet is the occasional meeting with his attorney and jail guards. Are you really okay with that? I am not. I am not. All right, let's check what's been happening here in the chat. Arthur Doctor, I've seen stories of not only other minors but adults too being kidnapped and held hostage in Indiana. Yeah, if you have Delphi as the center point and have a 250-mile radius around it, there are so many unsolved murders. It is ridiculous. Absolutely ridiculous. Dun, dun, dun. Is Rick Allen getting any help from any new lawyers? Well, he has his appellate attorneys going through everything now. Tammy, I don't see him getting released. I think the chances are slim to none. But they still have to, because it's a new judge. He might have other ideas. Oh, thank you, Gigi. Glad you're here. Please tap the like button if you haven't already. Thank you so much. Dun, dun. Can he do a habeas corpus? I think he already did. Dun, dun, dun. Malik Parker. This case needs to be tossed at this point. Yeah, I understand why people really are reluctant to tossing a case like this, a double homicide, with this amount of evidence. But again, how much do you want to allow the state to get away with? How much misconduct? There was not that long ago a person who has spent 27 years on death row. And then it was revealed that the lead detective in that case paid a jail informant to make up a story, a confession. So now that person is out of. I'd like to see if I can find it. Texas. This was just a couple of weeks ago. Dun, dun, dun. Here it is. Murder conviction of Texas woman on death row for 27 years tossed by federal appeals court. Prosecutors improperly used the jailhouse informant to help their homicide case against Brittany Marlowe Holberg, the court ruled. That was her 27 years ago. Brittany Marlowe Holberg was convicted in 1998 of robbing and murdering 8-year-old A.B. Towery in his home in Amarillo, Texas. Holberg, yeah. Let's see here. Holberg has always maintained that she ended Towery in self-defense after he started beating her. But at trial, prosecutors brought to the stand Holberg's cellmate, Vicky Marie Kirkpatrick, who testified that Holberg confided that she murdered Towery for the money, court records showed. Holberg denied having ever spoken to Kirkpatrick about the slaying. For frick's sake, Holberg defense lawyers and the jury had no knowledge that Kirkpatrick was a confidential informant for Amarillo police. At the time of Holberg's trial, the state knew about Kirkpatrick's confidential informant work for the Amarillo police, but presented her to the Amarillo jury as a disinterested individual who wanted to do the right thing and was attempting to be as truthful and complete as she could be. According to Judge Patrick E. Higginbotham, writing for the majority in the 5th U.S. Circuit Court of Appeals ruling, which was published Friday. This is a couple of weeks ago. The state did not disclose Kirkpatrick's work as a paid informant until after Holberg was sentenced to death. Holberg's counsel cross-examination of Kirkpatrick spanned only 6 pages of the trial transcript, a reality that speaks volumes. Judge Stuart Kyle Duncan, writing in dissent, argued that Kirkpatrick's testimony played only a small role in the case. Yeah, there's always somebody who makes that claim. Oh, it was only yeah, but and he claimed that so even had Kirkpatrick been impeached, there's zero chance that the jury would have credited Holberg's laughable claim of self-defense or spared her the death penalty for slaughtering a sick old man, Duncan wrote. Oh, you cunt. A sick old man? Oh, yeah. Guy was 80. He was also frequent with prostitutes, a known woman beater, known for many, many things. I believe. Let's see, who is this fucker? Stuart Kyle Duncan. Let's see who this. But for fuck's sake, what's going on here? He's a young guy. Yeah, don't know. Yeah, it's besides the point. The appellate court ruling kicks the case back to trial court. Randall County District Attorney Robert Lowe, previously a prosecutor on the case, said he's disappointed by the ruling, but wow, that this legal action is not over. Robert Love, previously a prosecutor on the case. So you knew too that the investigator paid for the testimony and you did nothing. The Texas Attorney General's office has been handling this appeal since 2010, and they are currently discussing the legal options available to the state of Texas in this case. Love said in a statement Wednesday evening, "Our office has agreed to not weigh in on the legal aspects of the case until the Attorney General's office has decided a course of action in this matter." Blah, blah, blah. Okay, that seems to be it. So yeah, 27 years on death row because the case the prosecutor and the lead detective believed was so weak, so they paid somebody to lie on the stand. How bloodthirsty can you be that you tell yourself, oh, I don't think the evidence will be enough. There might be a chance that the jury will go for the self-defense. Let's see what happens. And the investigator said, I can pay this woman to lie on the stand for us. And the prosecution said, good. I will put her on the stand. They were prepared to kill a person with the help of a paid by lying in court. Are you really out for justice then? Or are you just longing to kill without repercussions? Yeah. All right. That was about it what I had, at least pre-planned. Let's see, what else can we do today? Yeah, they want wins at trial so they can get re-elected. I know. That is one of the huge reasons to why I really, really do not like elected prosecutors. Let's see. Dun, dun, dun. Let's do some Judge Boyd as well. It's always fun to watch Judge Boyd. Dun, dun, dun. Let's go drive on your tractor. Definitely not now. Judge Boyd. Let's see here.
All right, court is calling 2024 CR 010581, State versus Macedonia, Claudio Jr. Can I have parties announced?
Major settlement state.
Survey bar for Mr. Macedonia Claudio.
And are you Mr. Claudio?
Yes, Your Honor.
Counsel, have you received all discovery and did you review it with your client?
We have to.
Probation, this is an application. And Mr. Claudio, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand you're charged with driving while intoxicated third or more as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea,
Okay, Gigi sent me a clip, but let's listen to this for a bit. And the clip she sent says, "Psycho ex-girlfriend falsifies police report, impeaches herself on the stand, and now the judge is pissed." Yeah. We can watch that after we listen a bit to Judge Boyd.
plea and gives you more than you bargained for. I'm sorry, I need that one back. This one's the one that's not signed. Sorry about that. Oops. It is getting a little bit crazy today. Just 1 second. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea bargain agreement, you were giving up those rights. Did you understand? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe that.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Claudio, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented? Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, punishment is to be assessed at 7 years in the prison, and the state recommends deferred adjudication. Did you understand that to be the plea? Defense is at the plea?
It's probation, Your Honor.
I'm sorry, probation. Thank you.
It is otherwise, Your Honor. Thank you.
All right, thank you. I'm sorry about that. State, did you understand that to be the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Hey, Val is
Counsel,
here.
have there been any such
Sorry, I
motions?
didn't see you.
Outside the agreement, the state is requesting that your community supervision be for a term of 6 years. There be a TAP evaluation, 200 hours of community service restitution, ignition interlock for half the term, DWI intervention, VIP live. Well, you're not allowed to drink alcohol while you're on probation, and there's to be 2-year driver's license suspension. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations?
Yes.
And did you also understand that as a condition of your probation, the court could sentence you up to 10 years in the Bexar County Jail? All right. Then to the offenses charged, how do you plea? State, any evidence?
And in Exhibit 1 and attachments, Judge.
With no objection, Your
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney?
Honor. Yes, Your Honor.
Did you understand it and sign it in all the appropriate places?
Yes, Your
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements, and police reports and judgments, but most importantly, there'll be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
And here she is, skimming through it. Now, if you enjoy Judge Boyd, I have now my playlist is getting is having a few streams and videos on it. So if you are a Judge Boyd fan, I have plenty of it.
Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
We are, Your Honor.
Anything you wish to say on behalf of your client?
We just asked the court to follow the plea agreement and entered into after a couple different discussions, not just with the ADAs, but Mr. Claudio himself. He's willing and able to handle any requirements that the court will impose in this probation, and I think that the gravity and seriousness of his facing here is actually quite helpful in terms of him being ready to do these things and take responsibility.
All right, and with regards to Woolsey, state, is there restitution for Britton Woolsey?
No, Your Honor, all of their costs were completely covered by liability insurance.
All right, and there's no deductible for them?
If there was, they did not mention.
All right, thank you. So probation, there's no restitution. All right, so how often do you drink alcohol?
How long?
Well, I mean, I'm sure after your DWI first, you said to that judge, oh, I no longer drink alcohol. And then when you pick up the second one, oh, Your Honor, I no longer drink alcohol. So obviously you have an issue with alcohol. Obviously you cannot drink alcohol at all because you can't stop when you start. It would have been so easy for this person that you had the car accident with to have been killed by you. And then you would have been here crying, and your family members probably would have been saying, please don't send him to prison. He's a good guy. Counsel, you've done a lot of DWIs. Have you ever had a client or known someone who said, my intention when I went out drinking was to become intoxicated and kill somebody?
I mean,
Nobody ever says that, but it ends up happening. So what I will tell you, when you're on probation, and it's not just for DWIs, it's for any probation case, you're not allowed to drink alcohol, period. If you drink alcohol, that's a violation of your probation. And in this case, if your probation is violated, you're looking at potentially 7 years in the prison. And what I do know is usually when people have DWIs and they go to prison, they end up serving the majority of that time. So what do you do for a living?
I work for a company called 4840 Solutions. It's a pallet company. We break down old pallets and rebuild new ones. So I've been there nearly 2 years, 3 years, 7, 8 months.
And what have you been doing to seek to
Oh,
maintain
she has
your
an
sobriety?
orange purse today.
Started going to lifetime recovery outpatient. I attend AA. I am enrolled. It starts May 3rd. I'm enrolled to the DWI intervention. I completed the VIP, the victim impact. I have my certificate for that.
Mhm.
And staying busy, work and home and with my family like I should have been doing.
Mhm. All right. And do you have any minor children?
My youngest is 12, going on 13.
All right. So, counsel, there is 10 days required at the Bexar County Jail. Sometimes in exchange for that, I will do partial GPS, but it will be partial GPS for work only.
Understood, Your Honor, and that's what we would ask respectfully, Your Honor. He is maintaining this job, and it is, that's one of the main reasons is that he's helping to support not only his son who lives in the home, who has some special needs, but also his wife and his mother as well. So I know that is exactly an important part of it. He understands what he stands to lose with that, so he will comply with all requirements.
All right, so if it's GPS, usually I waive the fees on that. They say there's a free GPS out there somewhere with no fees. I've never seen it. It's a unicorn. But with the GPS with the waive fees, probation may be able to do that with him through the probation, or he may have to go to the jail to pick it up from there.
Understood.
All right, so the court is going to sentence you to 7 years in the prison, suspended and probated for 6 years. There's to be regular reporting by Zoom or in person, regular random UAs with testing for alcohol, proof of employment within 30 days, no employment as a home health care provider or with minors, TAP evaluation out of custody, follow recommendations. There will be 30 days partial GPS for employment, waive fees, and that will be in lieu of 10 days in the Bear County Jail. State, do you have any objections to the defendant serving time on GPS as opposed to 10 days in the Bear County Jail?
Court of Public Opinion is trying to give links to their channel. Please ask first. Me or my mods will check it out, and if it turns out to be a legitimate thing, then of course. But ask first. Just don't just post and disappear.
All right. And so that the record can be clear, the court is doing this because one, I think it would be a hardship for you to serve the 10 days in jail. You'd probably lose your employment. And also there is an overcrowding issue at the jail. There are health issues at the jail. I've toured the jail. There is mold at the jail. So that is why it's 30 days. There's going to be ignition interlock half the term. You don't have ignition interlock on any vehicles you have access to. So if those vehicles belong to persons who are living at your home, you must have GPS on those. 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, the 200 hours will be deemed satisfied. DWI intervention, DWI education, and probation. Some of these classes he's already completed or he is almost completed. He can receive credit for that. VIP Live, 2-year driver's license suspension. Field visits 1 time per month for 6 months. 90 sober meetings in 90 days. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
Your Honor,
Yes.
I allow to look for new employment since I started my job after taxes. I was getting like $560. They cut our hours. Some checks are coming out for like 300 something or something.
Oh, yes, you're allowed to look for new employment. All right, just speak with probation about that.
Okay.
All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. I hope I don't need to tell you this again. There are some people who are driving around. They're just trying to go to a football game, Texas Friday Night Lights thing, or either they're driving somebody during the daytime. Everybody's just trying to get to their destination safely. And in Bexar County, there's an issue with people drinking and driving. They become impaired and they think they're not impaired. And then you end up with accidents and people dying. And then it's a tragedy. And let me just tell you, the public feels little to no sympathy to the person who's intoxicated and they hit someone and then they come to court crying, I never meant to do that. I have a family to support. So if you're not going to maintain your sobriety for yourself, which is really who it should be about, then maintain it for your son that you're supporting. You understand? If you ever need anything, let probation know. If you feel like they're not addressing it, you can come back to the court. If you feel like I'm about to stray from my sobriety, call probation, speak to your sponsor. If you feel they're not addressing it, you can come back to the court and we'll see what we can do to help you. All right. All right. Good luck to you.
Thank you for your time.
Thank you.
All right, this guy, DWI, and apparently with this severe repercussions, it might not have been his first one, but this time it seems like he's actually trying to do something about it. Now, let's see what this is all about. The link that Gigi sent me. The psycho ex-girlfriend who falsified a police report and then impeaches herself on the stand. Let's see what this is all about. Let's go for it. All right, let's see what this is all about. Dun, dun, dun.
The people of the state of Michigan versus
Oh,
Chase
Michigan.
24-03567FY. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people. Good morning, Your Honor. Dustin Coons for Chase Scruggs, who's here to my right.
Okay, today was the date that was scheduled for preliminary examination. I do have one bond violation that we were to address today. I have a new one. The allegations of this bond violation alleges Mr. Scruggs that on or about February 14th, 2025, at approximately 1:35, the alleged victim received a phone call from your number. This number was confirmed by her to the officer, and that the officer noted that this is also the number that was identified as yours on S card and S. The victim alleged that she did not answer the phone call. There's also allegations that in January 2025, that the victim received text messages from your mother. The victim's mother received text messages from your mother, a lengthy text message accusing the victim of ruining your life on purpose. So those would be violations of your bond conditions of no contact directly or indirectly with the victim. If you're found to be in violation of your bond on each of these allegations, you could be sentenced to contempt of court. It's 93 days in jail on each, the maximum penalty, and or $7,500 in fines each violation. You understand that? My understanding is he's entering a not guilty plea, correct? So any other preliminary matters before we take witnesses?
And just, I guess, so the record's clear, my understanding is the court will proceed on the hearing on the new bond violation today. Is that right?
Correct.
Okay.
Your Honor, I apologize. I guess the
the one thing I did want to put on the record is that the bond violation that we heard for previously with the car being cited outside, I don't think people can meet the burden on that particular one, so we're gonna request that we not move forward on that. However, with respect to the new allegations, the people are prepared to move forward. And the people, thank you, Your Honor. And the people call Olivia Winter-Shuck.
First, state your first and last name and spell vote.
Olivia,
I am going to take you back to October 27th of 2024. Do you remember anything unusual happening that day?
yes,
Do you remember your address where you stayed on that date?
626.
And is that address in the county of Ingham? Do you know a gentleman by the name of Chase Scruggs? How do you know Mr. Scruggs?
We had a relationship with my together.
How long was your relationship?
And then it was on and off for about 4 years.
Can you speak up, please?
It was on and off for about 4 years.
Thank you, ma'am. Would you recognize him if you saw him?
Yes, I did.
Do you see him in court today?
I did.
Can you point to him and identify an article of clothing?
Hi, Dolly.
With, Joe Jeffrey.
Your Honor, may the record reflect that he
Any objection?
No objection, Board, Your Honor.
Identification's noted.
So on October 27th, did you see Mr. Scruggs that day?
I did.
Can you tell the court about that interaction?
I believe that day, I had this friend dropped off at home with a friend. I heard some buses in my house. I had walked into my bedroom. My bedroom door, or my bedroom window was open. I'm sorry, and my air conditioner was sitting on the floor in my bedroom.
And was there somebody in your bedroom?
Yes, it was just,
The defendant was in your bedroom.
yes, sir.
I think you indicated the window was open and the air conditioning was on the floor.
Yes.
So, before it was on the floor, where was that air conditioner?
In the window.
The window that was open?
Yes.
That address, 6264 Cooper Road. Do you live alone there?
Mr.
do.
Jingles is here.
Has Mr. Scruggs ever shared that residence with you?
Yes, he did.
And prior to October 27th, how long had it been since he shared that residence with you?
Since he lived with me, it had been like a year and a half. But he was over just about every day. Up until probably August and September.
Okay. Does he have a key to your apartment?
No, not anymore.
Did he have a key to your apartment on that day?
Not that I'm aware.
Did he have permission to be at your home when you were not home?
No.
How do you know? Did he, had you communicated that to him?
That he was open.
Yes, ma'am.
No, I hadn't talked to him prior to.
Was there any reason, in your opinion, is there any reason he would have had to believe he was allowed to enter your home without present?
No, sir.
At that time, were you two in a relationship?
That must have.
You said he was on again, off again, correct? So at that time, was this an on again period?
At the time, no, but prior.
How long prior to that?
Like I said, it had split up about like August. In August of this year, or I'm sorry, last year.
So it had been more than 1 month, but almost 2 months?
Correct.
Okay. All right, so let's go back to the moment. What time of day was this?
It was nighttime. I want to say anywhere between like 8 p.m. to 9 p.m. Might have been a little bit earlier. I know it was in the evening, but
It was nighttime?
yeah, it was in the evening. Yes,
And was it late?
yes, it was dark out.
Okay. Do you remember approximately what time you called the police?
Mm.
You don't remember?
No, I called them shortly after though.
If I were to show you a statement that you gave to the police that night with respect to what time this incident occurred and when you called the police, do you think that would refresh your memory?
Yes.
Is that yes? Your Honor, may I approach?
Yes.
Handing you the police report with your statement to the police from October 27th. If you could just look it over, read it to yourself, and when you're finished, if you could just look up at me and let me know. Yep, does that refresh your memory?
Yes.
Okay, I'll take that back from you. Thank you, ma'am. So do you recall what time of night that was, ma'am?
And that's a hours, I'm not sure, but that's the day of
Hi, Christine.
What I'm sorry, I don't recognize the time.
So if I were to describe that time in international time as reflecting midnight,
Okay,
does that, do you have any reason to
Yeah,
believe
that
that would be incorrect?
no. no.
Okay,
I did call a little bit after, correct, yeah,
so it was after midnight on October 27th.
I did call a little bit after.
Okay. And you said you were dropped off, and did you say that you heard something in your home after you were dropped off, before you went inside?
As soon as I entered, I heard breakfast coming from my bedroom, so.
Okay. I assume you were surprised to see Mr. Scruggs in your bedroom.
Very,
What happened then, next?
I was in shock, I just stared at him and he left immediately out of my door. Out of the front door.
Can you explain to the court, how he left? What happened when you saw him and he tried to leave the home?
We didn't say anything, we just walked right past him, walked out of the door.
Did he make any kind of contact with you as he walked past you?
No,
You don't remember him touching you?
no.
When, with respect to the air condition that was on the floor, was it in that condition before you had left your house earlier that day?
No, sir, absolutely not.
Okay. Were you able to just determine how the air conditioning unit might have ended up on your floor?
I believe and wholeheartedly that he pushed it through the window to gain access into my home.
Why do you believe that?
He didn't have a key and he was standing in my room right next to the air conditioner with the window open.
Was there anything outside that helped support your conclusion?
When the detective or the officer had showed up, she did recognize footprints leading up to my window in the backyard.
Objection hearsay.
What a response to the objection.
I'll rephrase your honor. Did you look around outside in your backyard?
I did not prior, no.
After this incident, did you look outside in your backyard?
I did not until the officer had let me know.
Okay, after the officer let you know, did you go outside and look?
Yes, I did.
Okay, did you see anything outside your bedroom?
It was my daughter's flag that was pushed up to my window and the footprints that she was talking about other lines.
Okay, so, you saw the footprints then?
Correct.
And the slide up against your window, is that where you ordinarily keep it?
No,
Where do you ordinarily keep it?
it's by my back door, which is far to the left side of my house.
So as you're looking at the back side of your house, slide is ordinarily kept to the left of where your bedroom window is?
And my bedroom is on the far right on the other end of the house.
So, based on your own personal knowledge of how your backyard is ordinarily kept, did it appear to you that that slide had been moved?
Yes.
What was the condition of your bedroom?
I didn't notice anything out of the ordinary other than some money missing and my AC on the kitchen.
Okay. You said there was some money missing?
I did, yeah.
Did you report that to the police?
I did also, yes.
Okay. How much money was missing?
It was only $20 at the time.
It's what?
It was $20 at the time.
Where were you keeping this money?
I left everything at home, so I just went to my friends in my wallet and just put the houses in my wallet.
Okay.
Which was on my bed. I noted that to the officer as well.
And so while you were out of the house, the wallet was on your bed?
Yes.
Did you notice anything else missing?
No.
Was there a mess in your
You went out of the house with your wallet still on the bed? Yeah, no.
room?
No.
Did you notice anything damaged other than the air conditioning unit?
No.
Was the air conditioner operational after that incident?
It was, it just had like a rumbling to it kind of at first.
Does it still work?
Yes.
No further questions?
Good morning, Ms. Shook. I guess I want to clear up the timeline of this event a little bit, okay? We talked about October 27th, is that right?
Correct.
Okay, now, is it that would the incident that happened, was it the 26th going into the 27th or the 27th going into the 28th?
I believe it was the 26th going to 27th.
Okay, Saturday into a Sunday?
It 4 weeks.
And so if I guess if you showed up at your house just before midnight, that would have been October 26th, right? Okay, but if you showed up just after midnight, October 27th. Now you testified at first on direct examination, you thought maybe this was around 8 or 9 p.m. Okay. You remember talking to a police officer in the early morning hours of October 27th? She showed up quite a bit later, right?
Yes, 2 hours later, she had said that they were really busy.
And in fact, you had called even a few hours after noticing Mr. Scruggs in your home, is that right?
Correct.
Do you remember telling the officer that it was around 11:30 or 11:40 or midnight when Chase came in?
Like I said, I don't remember the exact time. I was really stunned when I seen him, so I was up looking at my phone and was trying to
Sure.
figure that.
But do you remember telling the officer that it was around that time?
Like it was right around that time. Like I said, it was evening, and so I felt like it dropped off late.
If you were to see a portion of your conversation with the officer, would that help refresh your memory about when you told her that Chase came to your house?
I mean, I believe you.
But
it would sure if you want me to look at it, yes, I would.
Your Honor, logistically, I have a video. Would you prefer I put it up on the screen to refresh your memory or to
A
her?
video is the body cam or everything?
Body cam.
That's fine, doesn't matter. You're trying to refresh your recollection of what time you called?
That of when she's saying that my client.
Oh, you can take your computer out.
I'm playing you a portion of the interview. You're going to be able to hear it, but this is really just to refresh your memory about when you told the officer that Chase got there. So after watching it, starting at 4 minutes, 40 seconds, it'll go for a little bit. I'll pause it, and then can you just let me know if that refreshed your memory? Okay. One second. I'm pausing at 5:16. Did that refresh your memory about what you told the officer?
Yes, like I said, it was late at night.
And so, in seeing that, did that refresh your memory that you told the officer that it was around midnight, maybe 11:30, 11:40?
Yes.
All right. And were you looking through your phone to try to figure out the time?
Yes, I was.
All right. Do you remember what specifically you were looking at that time?
What time I had called 911
Oh, well, okay.
is what I believe I was looking at.
But you called 911 a few hours after Chase was there, right?
No, I called shortly after, and then she had showed up hours after. So I called hours after. I called, I mean, maybe like an hour after, maybe, but it wasn't too long after. And then she had showed up about early in the morning.
You saying the officer showed up
Yes, ma'am.
hours later?
Yes.
So you did not call 911 at around just before 3 a.m.?
I may have. That was not so good. Call.
So let me get. You claim first around 9 p.m. something happened. You didn't call the cops, or you didn't get home until 11:30, 11:40, or midnight, and then you didn't call the cops until 3 a.m. It seems like this is edited. This thing.
All right.
Like I said, it wasn't too shortly after.
If I showed you some records that from dispatch, which is where 911 calls go, would that help refresh your memory about when you called 911?
Your Honor, I'm just gonna place a relevancy objection, at the moment. Just with respect to, I think the line of questioning is supposed to flesh out exactly what time the 911 call was made. I'm not sure the relevancy to the overall, case here.
Well, two things, Your Honor. I think the timeline of events is always relevant, but also, I mean, Ms. Shook just testified that she called 911 right away. And so if nothing else, as a matter of impeaching credibility on that point, should be able to see this.
Okay, but the objection's overruled.
Okay, thank you, Your Honor.
So if I showed you call logs from when you called 911, would that refresh your memory about when you called 911?
Yes.
May I approach you?
Yeah, but it's 2:52 in the morning.
Does that refresh your memory about when you called?
Yes, it does.
Okay. And is that when you called about 2:52 in the morning?
Yes, the officers always come in as long as I make contact within 12 hours of something happening at the report comes. My phone might have been dead at the time, which I'm pretty sure it was. And I did reference that to her, so
So you're off by either 3 or 6 hours.
I'm
Okay. You think your phone was dead at the time?
pretty sure it was. As soon as
So-
I had got home, I charged it and I took a shower.
So you were not-
But I definitely called within this time frame. I should have.
So you weren't calling Chase hundreds of times on the night of the 26th to the morning of the
Not
27th?
after that. No, I didn't.
No?
Not that I recall. Not after.
Prior to that?
I may have.
Prior to what? So I can
I'm
have
sorry.
context.
Yes,
Prior
I'm
to-
sorry. Prior to spotting him in your home,
I don't remember. But I was still gonna get some fresh and again back on my life.
I understand.
That wasn't a question, ma'am, strike that. My question though is what, when you say you may have called him prior to, what timeframe are you talking about, ma'am?
Oh, now the judge is interfering.
When he asked you if you had called the defendant hundreds of times, he asked prior to, you said you may have, and I'm trying to get time frame.
I don't remember.
You don't remember when? Okay.
And then it was, again, a few hours after even you called 911, that an officer showed up, right?
She said yes.
Yeah.
Just for my clarification, you refreshed your recollection, it was at what, 2:52
2:52
in the morning, AM or PM?
a.m. Your Honor.
Okay, thank you.
Right. Now, among the things you noticed, you saw my client where at in your bedroom, is that right?
Standing right in front of my window in my bedroom.
The window to your bedroom, which again is along the back side of the house.
Yes.
All right. And you noticed $20 missing?
Yes.
And you say you reported that to the police?
I should have. I mean, I was also distraught for the whole I mentioned, but she's seen my family door in the window open and went around the house and looked at it.
Well, you testified on direct examination that you did tell the police that there was $20 missing, right?
It was in October, I don't remember, but I know I had just realized it.
You said you saw footprints in your backyard after the officer,
Yes, she pointed them out to me
okay, pointed them out how?
with a flashlight. And told me that she had seen footprints back there in my house slide up against my window.
So
That
the
was
two,
open.
I'm sorry, the two of you went in the backyard together?
She had shown me out of my window, she said it was open.
So, and then you noticed there was a slide?
Yeah.
Okay, that was something you observed,
Yes,
Was-
she said she moved it back for me.
okay. But on direct examination, you said that you saw the slide behind your window where Chase supposedly broke in, right?
Yes, once she mentioned it to me, I did see the slide right there.
Right outside your window?
Yes,
Not where she moved it back to?
it was right outside my window still, and she said she moved it back for me. She did take photos.
Wait. Is she claiming that the responding officer saw a slide outside of your window and moved it and then took photos? Yeah, no.
Have you seen those photos?
I have.
I come back to that in just a moment. You said that you come in, you see Chase, right?
Yeah.
And he just walks past you out the front door?
Yes.
Was there any conversation?
No,
Was it, understanding the air conditioning unit was out of the window, was, you didn't notice anything else out of place?
no. I was also shocked and of seeing him staring at her. pay too much attention other than that to stuff right away.
Well, not right away, but you had hours to observe the scene after you
Right, I
left.
did, yes, so I
Okay.
didn't notice anything.
Okay.
So you didn't notice anything, is what you said?
I did not notice anything, no.
Right. And the AC unit, did you end up bringing that out of your bedroom to the living room?
It, yes, I did, I
Okay.
did, yeah, I drug it out there.
Okay.
So,
Just to,
just to get out of the way, yeah, and I was gonna close my window,
okay.
so, but then I wanted to wait for him to report.
And that, this was again, October 27th. Was it still warm out? Do you know? Do you remember?
No, you're too small.
I guess, let me ask you this. Do you normally take your window unit AC out of the window when it starts getting colder?
Yes, I usually don't have someone do it for me, so at the time I was waiting for someone to do it.
You said you lived alone at this home, is that right?
I do,
All right. And you do have a dog, right?
I do not anymore.
At the time?
Yes, I do.
Okay. What kind of dog?
I had a German Shepherd.
All right. Is that German Shepherd no chase?
Yes.
Was that dog friendly with chase or?
He was, yeah.
Right. So, did
I
you have?
had a dog at the time. But he was not friendly.
You had to lock up a dog
Yeah.
when the officer came to ask you questions, right?
Correct.
The dog was barking like the entire time, right?
Not when he was in.
So was the dog with you when you were out and about?
I don't remember.
Okay. I get, when you go out, you were out with your friends before coming home around midnight, right? Do you normally take your dog out with you?
Mhm.
Okay. So you don't remember if your dog was with you or not with you?
I don't recall, I'm sorry.
Do you remember the officer asking you if you've been in contact with Chase in the days leading up to him breaking in?
Yes, I do.
All right. And do you remember telling her something to the fact that your last conversation had just been a few days beforehand?
Yeah, it was quite a couple days beforehand. There was a lot of arguing back and forth, or conversations back to consistent.
I'm sorry, could you say that again?
Our conversations weren't very consistent at the time. Arguing back and forth a lot.
Well, you told the officer that you hadn't been arguing in the days leading up to the invasion, is that right?
Uh-oh.
And we go back and forth, we've been arguing, so like I said, it's been back and forth, we're on good terms and we're on bad terms.
But, so I mean, your testimony here, though, is that in the days leading up to October 26th, October 27th, you were arguing.
We may have been, we may not have been, I'm not
Well-
sure, like I said, we've been good and we've been bad.
But you testified earlier, like
Your Honor,
a minute or two ago, that you were arguing.
I'm gonna object, this is asked.
Well, no, I think it was not. I answered clearly. And I think that's why he's trying to clarify. She answered one way and then now I may have or may have not. And this all goes to her credibility.
No, I understand, Your Honor, I just.
Correct. So the objection to rule.
Thank you.
So you testified 2 minutes ago, if that,
Mhm.
that you had been arguing with Chase in the days leading up to this home invasion, right?
Because we may have been,
Well, that's not what you said first, though, is it?
like, it was in October, so I don't recall. It was tired.
Okay, and
I
that,
apologize for that. We bickered back and forth, so I can't tell if the days following back in October, if we were on good terms or if we were on bad.
do you remember telling the officer who was there interviewing you on the morning of the 27th that you had not been arguing with Chase in the days leading up to this home invasion? Okay, and so we've had a few minutes delay while I'm trying to get the technology working. Where we left off is you did not remember if you told the officer that you and Chase had not been arguing in the days leading up to the home invasion, right? So I'm playing part of that video starting at 5:30.
Conversation.
Thursday, he was at my mom's house with me.
Okay.
Well, he just showed up there
Okay.
because I had the kids there, and he came to see his daughter for a little bit, and then left. So that was like the most recent time we like seen each other in person and had a conversation like in person. or
Yeah.
Anything, which we didn't have an argument then.
Like it was chill.
Yeah, I mean, like we didn't really talk much.
Yeah.
But there wasn't.
But there was like no
animosity.
animosity. Yeah. There was like nothing crazy. And then if you guys like texted or anything since Thursday?
A little bit, but
Okay.
not like an argument. I know that previously he did come to my house and like take stuff out of my house, my friend.
All right. So you told the officer that you'd had a little contact with Chase between the Thursday when you two were visiting your child at your mother's house and then the day of the home invasion, right?
Correct. Between them, we did not.
What's that?
Correct. Between them, watching them, we did not have an argument.
All right. Now, did you leave a voicemail on Chase's phone on October 25th threatening to kill him?
Oh,
No.
You said not that you.
oh. Oh, wow. Yeah, she's digging. She's digging. Oh, this is good cross-examination. So you did not leave a voicemail threatening to kill him? Abba.
You recall?
I don't remember.
Around this time, did you? Well, what? And I don't want to. Fair to say you have a couple matters going on over at the circuit court on Kalamazoo. Is that right? Okay. I don't want to get into the details into those, but did that lead to a custody dispute between you and Chase?
Not necessarily.
Right. Well, what?
Oh, custody dispute. Oh, this is getting nasty. So they were in a custody dispute, and all of a sudden he's making home invasions. Yeah.
What was the situation with your shared daughter?
She was placed with my mother because she said you cannot get her.
And again, we're not going to get into details, but the daughter wasn't with you either. Is that right?
Correct.
Now, did you learn right around the time of this home invasion that Chase was trying to get sole custody of your daughter?
I did not. I was not aware of that.
Did you learn that prior to that, did Chase owe you child support?
Yes, he did.
All right. Did you learn around then that child support was going to be inverted and now you would owe child support?
Yes, but they revoked it since he doesn't have her at all.
Oh. Custody battle. He was seeking sole custody, which would mean that she would be owing him child support. Uh-oh. Would that be a reason for falsifying a home invasion?
She's with your mother, is that right?
Correct.
But-
Does not see her.
I'm sorry. I interrupted. Can you say that again?
He does not see her at all.
The question was, that she's with your mother?
Yes.
Oh.
Yes, she did.
But there were some custody issues right around the time of this home invasion complaint. Is that right?
Not necessarily. He was threatening to make sure I didn't see my kids ever again. That was about the only dispute we had.
That's all I have. Lori. Thank you.
I have a question. You said that when you saw Mr. Scruggs in your home, that no words were exchanged and then he walked out.
Yes, Your Honor.
Did you report that he shoved you at all?
He might have brushed past me when I walked by, but I don't think it was intentional.
Yeah, but that wasn't my question. Did you report that he shoved you?
I don't recall.
You can,
So, just briefly, I think you on cross-exam, you were asked a lot of questions about some of the details with respect to what you reported.
Yeah.
Is it fair to say that October was a long enough time ago that you don't remember every detail?
It's not only that, but it's also there's been a lot of stuff going on between me and him, where it's been a lot of incidents, police reports, stuff like that. So I don't. It's hard to recall everything and every
Okay.
situation that's occurred.
Okay, fair. On cross, there was some testimony about an ongoing custody issue between you and the defendant, and I'm sorry, it was your daughter, correct?
Yes, so
Okay, and because you share a child in common, you've had regular communication with the defendant regarding your child, is that fair to say?
I have tried, yes.
Okay, and you said you don't remember, I think on cross, you mentioned that you don't remember calling Mr. Scruggs after finding him in the bedroom, is that right?
I don't believe I did. I might have, but I don't recall. It was a while ago. There's been a lot going on.
Sure, fair to say. If I were to show you your statement to the police that night, would it help refresh your memory as to whether or not you tried to do that?
Yes.
Your Honor, may I approach?
Yes.
Okay, so I've marked on this police report, the part of your statement to the police that night. That might help refresh your memory. If you can just look it over silently and then look up when you've finished.
Yes, that makes sense. Yes.
Does that help refresh your memory, ma'am?
Yes.
Okay, so all right, after having looked at your statement to the police, do you recall whether or not you tried to call Mr. Scruggs after you found him in the bedroom?
Yes, like I said, we did not have any conversation. He just walked out and left. So randomly his wife and started on the fence. I initially why I didn't call the police. I was trying to figure it out, and then I was my house.
So when you tried to call him, did you have a conversation with him about why he was in your room?
He did not answer. No,
Do you recall whether or not you had called him more than once?
I don't remember.
Okay. But again, this is back in October, it's 4 months ago. There's other ongoing issues with him. Is it fair to say that?
Been a lot more.
Okay. But let's just say straighten the record out one more time. You testified on direct exam that you did see Mr. Scruggs in your bedroom after returning home.
Absolutely.
Mr. Scruggs did not have permission to be in your bedroom or in your house at that time, correct?
Absolutely.
And when you were looking through everything after he left, you discovered that $20 was missing from your wallet. Is that correct? And that was your wallet, not Mr. Scruggs' wallet?
Correct.
And it was on your bed?
Yes.
And you have no.
No, Dave, this isn't cross. This is a redirect. So let's see here. This should be the prosecutor at the far end. Over here at the very bottom of the picture, that's the defense attorney and the client. And on the stand, somewhere around here is the lying liar lies.
No other reason to believe anybody else but Mr. Scruggs would have left your home with that $20. Is that correct?
Was it the first time? Yeah. Yes.
Thank you, Mr. No further questions. Your Honor.
I have another question.
No, this isn't recross. This is redirect.
So you said after you saw him, you tried to call him?
But I do believe that defense attorney just lets the prosecution ask the questions to get more information into recross.
Yes, I did.
He didn't answer?
No, I didn't.
Okay, but when you were questioned by Mr. Coons and he asked you about calls, you said that your phone was dead.
It was, I don't remember exactly what time I called Chase, but I know my phone was supposed to die because I did plug it in when getting back to my friend's house.
And then I asked you too he asked you about calls prior to or during that time frame. And you say you didn't recall, and I asked you too. So are you now having a greater recollection?
I didn't recall until he showed me the police report of me, letting the officer know that I did call him after to see why he was in my home.
Okay. Mr. Coons, any cross based on my question?
Just briefly, so Chase didn't answer any of your calls, that's right?
No.
Sorry, let me rephrase the question. Is it your testimony that Chance did not answer any of your calls?
I don't believe he did.
Right, and you didn't have any other communication with him in the early morning hours of the 27th?
No.
Not even driving by his mother's house?
I don't believe so.
Okay.
I don't recall, I'm sorry, like you said, it was a while ago, there's been a lot going on, but a lot.
All right, that's all. Thank you.
Question on the PA-53.
On the PA-53, Your Honor?
Correct.
So, yes, Your Honor. Do you recall calling the police on February 14th of this year?
Yes, I do.
All right, and what was the reason for that phone call?
She just had called me that day, around about 1:34, 1:35 p.m., made a phone call to me.
Okay, so I think you started answering my next question. How do you know it was him? Oh, you're fine. That was a good answer. And you said it's from his number. How do you know it was his number?
It was, I don't have it saved, it was his, and I tried to go to the messages, and the messages previously that he had texted me asking if he should knock on my door and introduce himself to my phone.
So this was a number you recognized that belonging to Mr. Scruggs?
Absolutely.
And this is and because you had testified before that you have a child in common, you communicate regularly with Mr. Scruggs about your child?
Yes, but this is after the PPO was in place.
So on February 14th, there was a PPO and this matter was pending before the court, is that correct?
Yes, sir.
And is it your understanding that there is a no contact order against Mr. Scruggs precluding him from contacting you while this case is open?
Correct.
And so when that phone rang from that number, you recognized it as belonging to Mr. Scruggs, with whom you have a child in common, with whom prior to this matter and prior to the PPO.
Somehow, I think this also might come back to haunt her.
You've had regular contact with him regarding that?
Yeah.
And it was at that number?
Yes, I do not.
Did he leave a message?
No.
Did he call you or text you after that?
No.
And that was your report to the police with respect to?
Yes, aside from his mother texting my mom, I had let him know that also that he had asked me.
Okay, thank you. No further questions, John.
Ms. Schick, do you have your phone with you in court?
I do, and I can.
Would that show that there's a missed call from Chase?
Yep, absolutely.
Okay. Did you provide proof of a missed call
Yes, I
The go-
submitted it to evidence to K Brooks.
to evidence.com?
It was a link sent to me. I submitted the photos of his mother texting my mom like he asked, and then the phone call from her like he had asked me to.
Okay, you uploaded all of those.
Yes, and I still have it in my phone.
You uploaded, you said the text messages too?
Yes, I did. Yes, he asked me to send a screenshot of the phone number and then the messages to the federal phone call.
When did you do that?
It was the same day
So on the 14th?
that I had called, yes. He's right outside my house, that's why I had provided the photo.
Yeah. You said the officer stayed outside your house until you provided photos?
Yes, he sent me a link while sitting outside of my house
And
and
then,
said he was going to track the GPS further.
okay, and then was it your testimony that the officer waited until you uploaded photos before he left?
I mean, I would believe so. I was sitting on my couch watching him. And he sent me the link as I was sitting on the couch.
That obviously has not been turned over yet. So that was.
Well, Your Honor, so
Oh, so she uploaded it and it wasn't turned over. Uh-oh. Uh-oh.
I received this report yesterday afternoon. I checked Axon under this police report number. There's nothing shared with me. It doesn't mean it's not there. It just means that their admin hasn't shared it with our office and then shared with me. But because I just received this report yesterday, I haven't had a chance to follow up and make sure that I was given all the whatever was uploaded to Axon. I'm sorry.
I did bring the police report with me.
Well, I have the police report. That's fine.
Yeah, we have the police report. The evidence is what we need.
Yes, sir. And that prior to beginning today, that I want to share with you, the only thing I have for today with respect to this PA-53 is the witness's testimony.
Sounds good. And I move forward with her testimony today because she's already here and that avoids me having to resubpoena her back.
Oh, of course, yes. Just with respect to this evidence, I can follow up on that, and if the court prefer, I have no problem coming back with that evidence to share with the court.
Sounds good. That evidence will already have been turned over to Mr. Kuntz before then. Any other questions for this witness today?
No, Your Honor.
No, Your Honor, thank you.
Okay, and this witness be excused.
Yes, Your Honor.
Thank you, ma'am. You may be excused.
Oh, and we have 50 more minutes. I wonder what the rest will be.
Do you have another witness?
No further witnesses, Your Honor.
I'm inclined to adjourn now until the evidence on the PA 53
Yes, Your Honor.
is turned over. Reason being is I took testimony on both the underlying offense and the bond violation from one witness. And to be candid, I do have questions and concerns about the overall credibility of that testimony. So I think flushing out this next set of evidence might help answer some of the concerns. I don't know if there's just a lack of memory on some things, or if there's an intentional lack of memory on some important facts. If someone asks me if I called someone and told them I was going to kill them, my response is not going to be, I can't recall. And so,
Yeah.
because there was so much back and forth on timelines and events and whether or not you call the police immediately when it happened or 3 hours later, and was your phone dead or not, that will make some gray areas for me. I would rather have some more evidence turned over to flush that out. If we need to resubpoena her, we can do that. If we don't, then we'll just proceed to argument at the next date.
So, Your Honor, I was at, and I know this is not common, I planned on having my client testify and introducing exhibits.
You want to do that today?
Well, we're gonna come back anyway, Your Honor, so I guess I'll defer to the court. If we're gonna have to come back anyway, if the court wants to hear our proofs today.
We can take your proofs today.
Okay, all right, thank you, Your Honor.
We can call your witness.
I call Chase Scruggs to the stand, please.
Okay. Somehow I suspect now is the time we will find out what actually happened. Oh.
And I'm going to have your attorney voir dire you or question you about your right to remain silent, okay?
So Chase, you understand you're accused of some crimes here?
Yeah.
All right, we've got 2 accusations in this file, 1 home invasion, 2 domestic violence. You understand that?
Yes.
You understand those are serious offenses?
Yeah.
All right, and then there's another case that has 2 other allegations against you. You understand that?
Yeah.
You understand that in relation to all of those allegations and anything you possibly could be charged with, you have an absolute right not to incriminate yourself?
Yeah.
All right, and that means you do not have to testify in this case. You understand that?
Yeah.
And if you don't testify, your silence can't be used against you. You understand that?
Yeah.
Now fair to say we've talked about whether it was wise or not to testify today?
Yeah.
All right. And I've given you some advice on this.
Yeah.
Okay. And all that being said, is it your choice to testify today in your own defense at the preliminary examination?
Yeah.
Oh, so this is not trial, it is preliminary examination. Good to know.
Is the court satisfied with that waiver? Okay. So, Chase, I want to take you back to mid to late October 2024, okay?
Yeah.
All right. Specifically, on October 26th, 2024, did you break into Olivia Shook's house?
No.
October 27th, 2024, did you break into Olivia Shook's house?
No.
Okay. Now, did you have some contact with Olivia Shook in and around those dates?
Yes. A lot of repeated phone calls.
Let me stop you there. So you say yes, and then a lot of repeated phone calls. Putting aside the phone calls for now, had you seen Olivia within a few days of October 26th to 27th?
Yes, we have regular visits every Monday and Thursday. Our joint daughter, Zola Scruggs, at the mother's house.
And so Olivia's mother has guardianship of Zola, is that right?
Yes.
All right. And so you had seen each other you and Olivia had seen each other in that joint visitation on the Thursday before this alleged home invasion?
Yes.
Okay. And that would have been the 24th?
I believe so. I was looking at the calendar.
How do you recall that? I mean, was it a pleasant visit, unpleasant?
Very pleasant. I had brought my daughter, a lot of scrubs with me. She usually came to visit, but she enjoyed seeing her younger sister.
They're half sisters.
Yes,
Technically.
like they're full sisters. I would reach that, but yes,
Blood goes through there.
everybody got along. Her mom was aware. Like I said, I've been through every visit that's been scheduled since the visit was still. We had normal conversations. With her mom had normal conversations. The kids played. It's usually from 5 to 7 p.m. A lot of scheduled time.
Shortly before that day, Thursday, October 24th, had you taken any action with a friend of the court?
We were kind of going through everything. A lot of me and her mom was, that she has the guardianship, trying to figure out how to get the necessary Medicaid, keep her in school, and things like that. I wasn't very privy to everything that was going on with her case, because there was a couple different charges and
So-
dates.
Right. So, and we're not going to get into it, but again, Olivia's dealing with some stuff down the street on Kalamazoo, and you're aware of that?
Vaguely.
Okay. And we don't want to talk too much about that, but you're going through Olivia's mom. Is that Sarah?
Yeah.
Sarah Smith. All right. You're talking to Sarah Smith about taking care of Zola.
Yeah.
All right. And in the months before October of 2024, were you paying child support?
Yeah.
Okay. That was court ordered?
Yeah.
All right. And then did that change at some point?
Yeah.
When did that change? Do you know?
Around the time these incidents happened, they had excused like the first expenses and things like that. And we're now transferring over accounts that I was paying that she was supposed to pay.
All right. Now, made mention of some phone calls. In the days after that October 24th, 2024 visit, did Olivia call you?
Yes.
A couple times or more than that?
At one point, I had counted close to 900 calls within a 3-day period. It might be more. That
900 calls. Let's hear that
A
again.
couple times or more than that?
at one point, I had counted close to 900 calls within a 3-day period. It might be more.
900 calls within a 3-day period? Oh boy. Oh boy. Somehow that a restraining order might not be on him, but might be on her. Good night, Dave. Good night, Dave. Welcome to the replay crew.
Imagine just going through them. That was just count of what I had.
Did Olivia leave you any voicemails in that period of time? That you remember?
Yes, on October 25th.
So she left you a voicemail.
Yeah.
Right? And let me ask you this before we get into the evidence. Do you have Olivia saved as contact in your phone?
Yeah.
How do you have her saved?
Crazy.
That's the contact name.
Yeah.
You understand that could be taken as in poor taste to label someone as crazy in your contacts.
Yes, but I felt it appropriate.
Okay. Did you go through your phone to find any evidence of these calls?
Yeah.
All right. Have you provided that to me?
Yeah.
900 calls in a 3-day. Yeah.
It looks like, I can't figure out what this is trying to say. It's
No.
How is the state even trying to prosecute this?
But this is a call from 2 days before the. So. I think I understand that this is going toward credibility. I'm going to object to this evidence as being irrelevant to the home invasion. However, I'll defer to the court's ruling.
I don't even have a clue what the evidence is.
Yeah, I'm going to object to this evidence, but I'll allow.
What's the evidence?
Your Honor, if you recall, Ms. Shook testified she did not recall whether she left a voicemail threatening to kill my client on October 25th.
Sounds like
I plan on introducing evidence, both of the actual audio, but then also the little transcript that pops up in the voicemail application,
visual voicemail.
just to put a date and time on it.
But I think it's improper impeachment because the testimony was that she doesn't recall. She's not denying that these things happen. She's just saying.
You're the state, you fucker. Seriously. How? With the because you have to have had a knowledge of this. And you charged him?
Saying that a lot has happened. She can't recall when something was done and when something hasn't. So I think this would
Right, and to the extent, well, I don't know that because she can't because her response was that she can't recall, that this would make it improper testimony because you can still be lying about not recalling. And if the evidence is that there were 900 calls, when she was asked if she made calls, she recalls.
Yeah.
You didn't forget 900 calls. Like, that's a lot of work.
well, I mean,
And then if the question that struck me as concerning was whether or not she had called and left him a voicemail threatening to kill him, and her response wasn't no. It was, I don't recall. Threatening to kill somebody, typically, I don't know. I would remember if I threatened to kill somebody. So unless there was something, and she wasn't questioned about whether or not there was something that's going on with her mentally or health-wise that would affect her memory, then I would believe that a reasonable person should be able to remember these answers or give an answer as to whether or not you threatened to kill somebody on a voicemail or not. So for the purposes of laying the foundation for impeaching the credibility of the witness, I'll allow him to proceed.
thank you.
Jason, did they leave you a voicemail on October 25th?
Yeah.
All right. And did you provide the audio of that to me?
Yeah.
Right. And have you had a chance to listen to it yourself?
Oh, please play it,
Honestly,
play
not
it, play it.
until
Please play it, please
everything
play
got
it, please
started,
play
I
it.
never really listened to the voicemail.
Oh,
But,
please play
but
it.
between, since this case began, you've reviewed it.
Yeah.
You listened to the voicemail before providing it to me?
Yeah.
Is what you provided to me the same as what was on your phone?
Yeah.
You haven't altered it in any way?
No.
All right. Did you also take a screenshot of like the transcript
Yeah.
of the voicemail? And you did that on your iPhone 16?
Yeah.
Good choice.
All
Good
right.
choice.
And you sent that to me?
Yeah.
Did you alter it in any way before sending it to me?
No.
Move to admit defendants A and B on this flash drive. A being the transcript, B being the actual audio.
Okay, the objection was noted.
Thank you, Your Honor.
A and B is admitted.
Okay, so Chase, I'm showing you what's been admitted as defendant's exhibit A. Is this is the transcript that you sent me?
Yeah.
All right, what is the date and time?
Looks like October 25th, 2024, 2:40 p.m.
All right, so that would have been the day after you had the visit with Zola.
Correct.
Right.
Bitch, you really got me so fucked up. Like, you literally fucking gave me some shit. Again, like, I'm so fucking pissed off at you. And I know you fucking lying about being at work. Because, first off, there ain't even no fucking things today. I have her on my fucking phones, too. Nothing was available today. And you even fucking told me last night you didn't have to work. You said you only had shit to take care of. He was like, I don't have to work. I told you I just had shit to do. But obviously it wasn't shit to do because you ain't even been ignoring my call. You just fucking muted my shit and put me on silent. So obviously you fucking with some bitch and you're busy being fucking laid up. Like, you dumbass fucking hoe. You dumbass bitch. I swear to God, yo, I'm gonna fucking track you down, and when I see you, I'm gonna fucking kill you. Like, you weird as fuck. You big ass, fucking hippie ass, gay ass nigga.
Oh.
Oye, ¿qué pasó? Blackout, blackout.
Oh, yeah, I'm demonetized. Okay. How the poppycock did the prosecutor go ahead with this file? I don't know. Maybe because he's medically retarded. I have no idea.
Voice in that voicemail?
Yeah.
That was her? Okay.
Ah!
Do you recall Olivia contacting you hundreds of times between October 25th and 28th?
Yeah.
Does that include like the hours around midnight of the night of the 26th going into the 27th?
Yes, they were time. At the same time. Not even minutes apart.
No, on the flash drive I have Appendix C, which is I'm moving to admit. Well, I can lay a better foundation, but moving to admit the screenshots of these phone calls from October 25th to October 28th. These have been provided to the people, I should say.
October 25th and October 26th. There's screenshots that show what again? How many phone calls?
The missed calls.
Missed calls?
Yeah.
Any
The
object-
calls missed.
Any objection?
I'll stand by my prior objection, Your Honor.
Okay, the total, defense,
That was a prosecutor. You can I know from I have the closed captions over it, but you can see him just slumping more and more down his chair. That is a prosecutor who did zero due diligence. Absolute zero.
this will be C,
Yes, Your Honor.
submitted.
All right. You provide screenshots of these calls to me. Is that right?
Yeah.
All right. And are the screenshots you provide me accurate depictions of what was in your phone?
Yeah.
Right. So I'm not gonna go through all of them, but I want to start with this one. Can you make out the date? Can you see that, Chase?
October 25th, 2024.
All right. And do you see? I mean, there are several missed calls on there.
Yeah.
Right. Spanning from 5:33 p.m. to 8:42 p.m.
Yeah.
All right. I'm gonna go to the next one. Also October 26th.
Yeah.
All right. Also, I mean, a lot of missed calls between 8:52 and 9:11 p.m.
Yeah.
And the next one, same date.
Yeah.
9:13 to 9:26 p.m.
Yeah.
Next one, same date.
Yeah.
9:30 to 9:36 p.m.
Yeah.
Next one, same date.
Yeah.
9:38 to 9:47. And same date. Two of them at 9:48.
Yeah.
Next one, same date.
Yeah.
Handful from 9:49 to 9:53.
Yeah.
Same date, 9:54 to 9:59.
Yeah.
Same date, 10 to 10:08.
Yeah.
Same date, 10:09 to 10:14.
Yeah.
Same date, 10:15 to 10:32.
Yeah.
Same date, 10:33 to 10:38.
Yeah.
Same date, 10:47 to 10:50.
That's a lot of calls. That's a load of calls.
Yeah.
Same date, two of them at 11:03.
Yeah.
And that he has her listed under crazy. Yep. Yep.
Same date, three between 11:07 and 11:08.
Yeah.
Same date, three more.
Yeah.
So this is the exact date that she claims he broke in.
Same date, quite a few more between 11:15 and 11:29.
Yeah.
Same date, 11:31 to 11:34.
Yeah.
Same date, 11:36 to 11:37.
Yeah.
Same date, 11:37, 11:41. Is that right?
Yeah.
Now these are not missed calls. Is that right?
Yeah.
Did you answer these 2 calls?
Yeah.
All right. And it looks like you talked for a very short period of time on one of them.
Yeah.
Right. 3 minutes on another.
Yeah.
Do you remember specifically what you guys talked about?
If I had to guess, I would ask her to stop calling me. But we calls going on all day. I was out getting the photos for our children, so I was trying to keep in contact with my mom and her mom, and I couldn't call. Like I didn't even get a call out.
Okay, fair enough. Did you, at that time, did you talk about being in her home unlawfully around that time?
No.
All right, next one, we've got more, still October 26th, a bunch of calls from 11:45 to 11:56.
Yeah.
And then looks like another answered call at 11:57.
Yeah.
And then now we're into October 27th, right?
Yeah.
Got 3 missed calls, 12:02 to 12:04.
Yeah.
Same day, 12:04 to 12:14.
Yeah.
All right. And you heard Ms. Shook testify that you broke into her home around 11:30, 11:40 midnight. Is that right?
Yeah.
Okay. So she was calling him for hours constantly with a dead phone at the time she claimed he broke into her home. Yeah, no.
Is it still your testimony that you did not break into her home?
Yeah.
Continuing with Exhibit C, next photo, we see another missed call at 12:04.
Yeah.
And I want to say, you testified that you have Olivia saved as crazy in your phone. Is that right?
Yeah.
Okay. Do you see a phone number on some of these screenshots?
Yes.
What is that number?
517-605-8665.
Oh, there's
Is that the
more.
number you have saved for Olivia?
Yes, that's what she got her new phone.
Next one, a few more at the 12:47, 12:48.
Yeah.
All right, and then the next one, we see a handful of answered calls throughout the night, 12:49, 1:13, 1:54, 2:18, 2:28, 2:29.
Yeah.
Again, do you remember specifically, do you remember what you're talking about? Don't guess, do you know?
No, I can't say for sure.
But you did talk to her on the morning of October 27th.
Yes, we did.
Next one, we can't see a date on this photo, can we?
I think that's a continuation of probably one of the other photos. Some of them have 50 or 100 calls in there, so I have to break it down each time. So
Keep going. Did these calls continue throughout the morning of October 27th?
yeah,
Was it about this constant pretty much all night?
yeah,
In the 3 o'clock hour?
yeah,
In the 4 o'clock hour?
yeah.
In the 5 o'clock hour?
So she only paused to call the cops.
I guess so. I wasn't sleeping.
Right. Do you remember anything else unusual happening with Olivia in the early morning hours of October 27th?
She had continued calling, and I heard a horn outside of my bedroom window, from which I observed Miss Shook driving by my house, just laying on the horn, honking the horn, trying to get my attention, but not answering her call.
You say you're home. Where is this?
So she called the cops showed up, took a report, and then she drove to his house, laying on the horn while calling him constantly. Mr. Prosecutor, how about due diligence? This is legitimately crazy. And for all you guys out there, I know it's fun I know it's good. It's not worth it. Don't stick your dick in crazy. Okay? Do not stick your dick in crazy. It's not worth it.
Then 4911.
All right, is that your home? Somebody else's?
It's my mom's home. Who I've lived with since. 2 years.
About what time was this? Do you know?
The date that
That she drove, you said that.
October 27th.
Oh, okay. What time though? Do you know the time?
It was the early morning hours. I wanted to say it started maybe like 2, 3, 24. I made 2 911 calls during that time.
Oh, you did
Did
911
you also
call.
get any video evidence of this?
Yes.
Of Ms. Shook driving past your
He caught her on video.
mother's home?
Yes.
Did you provide that to me?
Yeah.
Is what you provide to me, well, what did you provide to me in relation to Ms. Shook driving by your mother's home?
Video evidence that I took, one from the top of my bedroom window, one from outside.
Right. And did you also send me any screenshots in relation to this?
Yes.
And what was the purpose of the screenshots?
To show the date and time of the offense.
And this is in your Photos app on your iPhone?
Yes.
You did not materially alter any of those things before turning them over to me? I moved to admit defendants dependencies D1, D2, D3, and D4, which is
Any objections?
Same objection, Your Honor.
Defense D is admitted over objection.
first Chase. I want to open up.
Oh, we're going
I'm
to
showing
see
you
it.
D1.
We're
What are
going
we
to
looking
see
at?
it.
Ms. Shook's car coming and passing my car that's parked on the street in front of my parents' home.
Is this a screenshot you took of one of the videos?
Gigi says, how come this defense attorney is? Yeah, because he has receipts. He has actual receipts. Oh, wow.
Yeah.
All right. Do you see the date and time on there?
Here, no, but I know they were on October 27th.
It's probably 2 hours. Yeah.
2:36 a.m.
On October 27th?
This is so going to be
Then
a
we're going to go
separate video.
to D2. Is this the video?
Yeah.
From that screenshot?
That's one.
Now, you were a little far away. Were you able to recognize that as Ms. Shook's car?
Yes, the black Ford Taurus. At the time, I believe she had no license plate.
And then you said there was another video you took from the street?
Yes, one a little bit closer.
Right. So looking at D3, is this a screenshot you took from that next video?
Yeah,
And when was that taken?
at 2:42.
On October 27th?
Yeah.
And actually, in that screenshot, no, it's a little blurry. Do you know who's in that car?
Ms. Shook.
And he went out because she did another drive-by. Hello! What are we watching? We are watching a pre-trial hearing where a woman claims her ex was breaking into her home at around midnight. And she doesn't recall if she called him or not the day or days prior or anything. And then here is the defendant showing that she called him 900 times in a 3-day period. And during the time where she says he broke into her home, she was calling him. And after she put in a fake 911 call or called 911. She decided to go to his place while calling him up to 3 times a minute, honking the horn outside of his house. That is what we are watching.
That was Ms. Shook driving by.
Yes.
Question, on this particular clip, are you outside?
Yes, I'm outside on my front lawn,
Okay.
so that way I could get a clear view of the car and Miss Shook.
Okay, so the first one, it looks like you were inside the house?
Yeah,
or-
that's when I first, that was probably the second or third time that she
Sure.
came by. The first time, like I said, I didn't capture anything, but I had a feeling that she may come back, so I wanted to try to get it back there.
Talk about, or we talked a little bit about the custody issues going around the time of October, October of 2024, right?
Yeah.
All right. Did you ever receive a friend of the court recommendation in relation to that?
I do believe I did.
Does that look like what you would have received from friend of the court?
Yeah.
All right. And again, this is surrounding custody and child support of Zola.
Yeah.
Your Honor, I'd move to admit defendants F, which is again custody, a front of the court recommendation from 30th Circuit.
No. She is not accused of anything. The prosecution is charging him with burglary and stuff. And now he is on the stand showing receipts that she is stalking him and making shit up. So she's not accused of anything. She's the accuser.
I don't see how this is relevant to the home invasion.
That's what I'm trying to understand.
Well, Your Honor, I think the court can tell that my crux of the case is that Ms. Shook is not a credible complainant, and
I'm gonna be frank, I don't think you need it.
I understand, Your Honor.
Oh, let's play that again. Let's play that again.
And
I'm gonna be frank, I don't think you need it.
Judge doesn't think he needs it in order to have her as a non-credible witness.
I understand, Your Honor, but this just shows that what I plan on showing it is that this friend of the court recommendation was mailed out on October 24th, the same day of their visit. Meaning the calls start the next day. Doesn't.
Okay, he can testify as to it, I don't need to see it.
Okay, thank you, Your Honor.
Okay. Chase,
And
did you?
And the prosecutor just sinks down more and more in his seat.
You receive a copy of the front of the court paperwork around the time of all these phone calls and the alleged home invasion incident?
Yeah.
All right. Do you, only if you have personal knowledge, do you know if Olivia also received a copy?
Yes, because she responded to the letter to the judge.
Okay. Is that something you learned after the fact?
Yes.
All right,
But
Chase,
she
that's all I've got for you
responded
right
to
now.
it?
Just as a reminder, the prosecutor did ask you some questions. So.
You have a child in common with Ms. Shook, right?
Yeah.
And you do not have custody of that child, is that correct?
No, not full custody.
So you have partial custody?
Legal rights to her. Okay.
When was the last time you saw your daughter?
Prosecutor, this is a time when you sit down, shut up, and dismiss the case.
Don't remember?
Actually, that last visit, because after October 30th, we had another incident at my house. So Ms. Shook spitting on me. So I contacted her mother and we decided that we did not really.
You say Ms. Shook spit on you.
Yes,
Was that in the same month of October?
yes, October 30th.
October 30th? Do you remember an allegation against you stemming from October 2nd?
Yes.
There's some harassment between you and Ms. Shook, correct?
Yeah.
You were sharing some pictures of Ms. Shook, correct? That was October 2nd.
Yeah.
Who is Chase Hendricks?
That's my Facebook profile.
That's your Facebook profile?
Yeah.
Remember sending a message to Ms. Shook that you should have died in that car crash or during your surgery? Yeah. You sent that to Ms. Shook?
Yeah.
This is relevant.
This is relevant with respect to the defendant's credibility with respect to the allegations he's making that he didn't do anything. This is just the witness making it up. So this.
You're saying, I don't think he testified he didn't do anything. I don't think there's a dispute as to whether or not they had a contentious relationship. He said he didn't break into her house. How is this relevant to home invasion first and a domestic violence?
Uh-oh. Judge is not having this.
It's going against the defendant's credibility with his claim. It seems pretty clear that the defense in this case is that the witness here is making up these allegations because she's got something against this defendant.
Well, it's not just an allegation. They've just put on the record countless exhibits that showed a timeline of phone calls. So unless you're telling me that this was something that took place during that time or somehow connects to this case, it's not relevant.
Well, this is all in the month of October. This also goes to
when in October.
The defendant just testified that this happened around October 2nd. So this has been 25
not relevant.
days.
Move on.
The phone call that was placed, that you played here, correct? You remember testifying that was her leaving a voicemail?
Yeah.
That was because you had given her an STD, correct?
No.
You had given her some sort of HPV and she was pissed off and calling you about it?
No, sir. I've actually gotten tested multiple times since then on my test came back clear.
Oh, shit! So she claims that he gave her an STD and he has had himself tested and he does not have an STD. Oh, for frick's sake, prosecutor, give it up. You're lost. It's gone. It's gone. Oh, God.
I want to say my most recent one was probably November 5th, actually. At work, really don't say.
Okay, you don't need to keep going into your protected health information.
So there was some testimony where the defendant says that she doesn't recall whether or not you had sent a message threatening her life, but do you recall sending her a message that says, and fair warning, don't try to be funny, and you got a girlfriend, or so you got a GM or GF, BM, Lil, yeah, or whatever, because it's a lot of whatever that is. Y'all wouldn't guess been down through there, or you see my name in they phone, so keep it P, laughing face. I don't miss my shots too often. Don't make me get to shooting again. That Ben's parked in a neighborhood near you type shit. You remember sending that to her?
That wasn't sent to her, that was posted on my Facebook story.
That was posted on your Facebook story?
Yeah.
Was that intended for her?
No.
When was that?
Oh, prosecutor. If you're going to aim for something, make damn sure you're aiming in the right direction and not in your own foot. Let's say foot.
Posted?
When was that posted?
And recall after that, actually when I posted it.
Was it before October 27th?
Yeah.
Was it around October 27th?
No.
If it's not related to this incident, I don't want to go through the history of their back and forth relationship.
Your Honor, it also goes to the defendant's mental state when it comes to why he would want to enter the home on October 27th. This is an ongoing issue where he's
We just looked through her call history to him, and she was calling him throughout the timeline and timestamps that she says that he broke in to her place. Motherfucker, stop! Just stop.
harassing the witness. The witness
He's
also.
harassing Mr. Nagle. I just had 900 phone calls.
Yes, Your Honor.
Let me stop you. I'm not going to sit here and let you try to go back in time till early October, September, and try to create something that shows, or if you want to read or to cross-examine him, you're going to have to talk about the incident or something tangentially close to the incident. This is 900 calls that just came in around the same time. Not the same time, at the same time that your witness testified that he was in her house. The same time that she said he was in her house, I just saw evidence that she was blowing his phone up.
I saw the evidence too, Your Honor, but I believe the phone calls came in around 2:45, 3 o'clock.
No. I saw. We started at on October 26th. We went through the whole entire day, back to back, minute on the minute, the same exact time that she claims he was in her house. She also claimed that her phone was dead. She also said she didn't remember if she called him. She also said that she was out with friends during the time that she's blowing his phone call up. And then I saw evidence, by way of video evidence, of where she's driving by the house, laying on the horn obnoxiously, and shortly thereafter, there's a phone call to the police.
But the point here, Your Honor, is that this is an ongoing thing between the two of them. They're both.
I don't dispute that there's an ongoing thing between the two of them. What happened in their relationship that caused the demise of the relationship really is not relevant to whether or not he committed a home invasion. The only reason why those phone calls and things were relevant is because they dispute the timeline that she's giving. I do not believe that they had a relationship that was full of pleasantries and that he probably didn't say some things that was egregious. I don't care if he gave her STD or not. That doesn't mean that you get to accuse him of something that's not true. So unless you're going to show us where it was true by your cross-examination, showing me that he made a post October 2nd has nothing to do with what happened on the 27th.
It leads up to that.
No, it does not lead up to that. It has nothing to do with it. Unless his post was, I'm breaking into your house on the 27th without your permission.
The people who arrest here, Your Honor, will come back about the PA-53.
I'm not moving forward with the PA-53 because there's zero credibility of your witness. Zero.
Understood, Your Honor. That's fine.
So you can try to restore your witness. I think she's still here, but that's up to you.
The people will arrest you.
Thank you.
The judge just told the state, put her back on. I think she's still here. And she said, people rest. This is wonderful. But seriously, prosecutor, what the fuck? What the actual fuck? You have to have known about this.
You can be removed from the stand, sir.
Just so there's a clean record, no redirect, Your Honor.
Thank you. Do you intend to give any argument?
Yes, Your Honor. Nothing offered by the defense vitiates the whether or not the.
Oh no! He's talking! He's still talking! No! Shut the fuck up! Accept defeat! Saying, self-dismissed. We fucked up. Sorry for wasting the court's time and move on. No, he has to talk. Oh God.
The defendant was present in the home on October 27th. there's a long history between this defendant and the witness, going back a long time, where the both of them are harassing each other. I do understand that there's some credibility issues with the witness.
Some credibility issues? All of their credibility issues. Oh my God. Folks, this is why this is a prosecutor that doesn't care about justice. He has put his credibility on the line for a conviction. And you see it in the bigger cases, but this is a tiny case. Imagine how he would do in a murder case or a rape case or whatever case. If he is this adamant, despite everything, absolutely everything telling him, your victim is lying, and he still has to argue.
Witness. There is some misunderstanding of, or not misunderstanding, but there is some inconsistencies with the timeline. But given the history between the two, I believe that question of credibility between the defendant and the victim should be better left to the jury.
Oh, you
The credibility of the victim is up to the judge today.
It is, yes, I understand. What I'm saying is, because there's an issue of credibility, according to the people's position, is that there's a question of credibility between the defendant and the victim. The people's position is that would be a question best left to the jury.
That's not consistent with the law. The law says the court is the sole determiner of credibility of the witness at the exam. Not that credibility issue should be fleshed out by a jury. Sole determiner is the judge, and that's today.
Great, understand.
Any further argument?
The people are ready.
Ever so briefly, Your Honor. People versus Anderson, 501 Mich 175 says exactly what Your Honor is saying, that you are the trier of fact today. You make the determinations on credibility. I think we've got a pretty clean record about why Bishop is not credible and why there's not even probable cause to believe that Jay Scruggs committed home invasion or domestic violence. For asking for dismissal. Thank you.
Thank you. Today was the date for the preliminary examination. The burden was on the prosecution to establish that they had sufficient probable cause that the allegations of the felony, because we're not addressing the domestic violence, or at least we don't need to, although the domestic violence is going to be dismissed on the statements made by the witness anyways, that there was more likely than not a felony that was committed, and that you were the person who committed the felony. So this is not an imaginary burden here. It's got to be more than mere suspicion, and it's based on the evidence that's presented today by way of testimony or other evidence. The court is the sole determiner of credibility at a preliminary examination. The burden is flexible, and the court also is in the position of measuring the likelihood that the evidence will raise reasonable doubt at the time of trial. That's part of my job today, not to just hear things and then decide that there's issues, but let it be flushed out at a jury. I've heard testimony today. We could go over the elements of home invasion, but the concern that the court has that is disturbing to me is that the evidence that was presented, it's very uncommon for a defendant to take this stand at a preliminary examination.
Very true. Very
the
true.
fact that the defendant took the stand and all this information or evidence that was supposedly turned over to the prosecution was not used to flush out the likelihood of the people's ability to sustain their burden, and that nothing was done in the interest of justice considering that information. There's no one, I don't think you need to have a law background to look at this evidence and see the glaring issues here in this case based on the time.
No, you do not need a background in law. to figure this one out.
timeline that's presented. I had testimony of one witness today, that being Olivia Shook, testifying that she had been in a dating relationship with the defendant, Mr. Scruggs, and that on the date and time in question, that being on or about the 26th or the 27th of October 2024, that he entered her home without permission. There's also, based on the complaint, a domestic violence charge, and that's because she reported, or at least when the question asked her about, the court questioned her about reporting, that he assaulted her, or that he shoved her, because that was the information in the affidavit of probable cause leading to the court granting the charge. She stated that she may have reported that, but that she doesn't believe that if he shoved her, that it was intentional, or that he brushed up against her, that was intentional. The testimony that she gave today on direct was that she returned home after being out, and she wasn't clear on the timeline, that she was surprised to see Mr. Scruggs in her home, that he stared at her, or she stared at him, and then he walked out. And that the police were called, lit footprints, and something to the effect of her child's slide was pushed up to the door or the window, and potentially how he gained access. And then that $20 was later found to be missing. It got very strange for me when the timeline got so conscrewed about what time the incident occurred and what time she called the police. It later was determined on cross-examination that she actually called the police at about 2:52 in the morning, which was contrary to the testimony she gave in her direct examination. The other thing that was concerning was that she alleged that the breaking and entering or the home invasion, I should say, took place at approximately 11:30 to 12 o'clock. If someone broke and entered in my home and assaulted me, I'm not waiting almost 4 hours to call the police. And she claims that, well, maybe her phone was dead, and that's why she waited to call the police. Then she testified that when asked if she had made phone calls to the defendant during this time or prior to this time, she said she did not recall. Then when asked her, when her questions or responses about whether or not she and the defendant had been arguing or feuding during the days prior to, she wasn't clear then either. She can't recall much of anything. Specifically asked if she left a message voicemail for the defendant threatening to kill him. I can't recall. There was no testimony or evidence otherwise presented that would establish that she has a capacity or an issue in her brain that affects her memory or recollection of this incident. And I recognize it took place October 2027, but if I threatened to kill somebody or I called someone after they broke into my home and asked them why, I think I might remember some of those facts. But what's glaring is that the evidence that was submitted during the direct examination of the defendant demonstrates over 900 phone calls based on his testimony from the alleged victim to the defendant, starting, I don't know if it started the day prior, but the days that he presented in the video shows me at least all day the 26th, he's getting nonstop phone calls from the victim or the alleged victim. And I'm talking about every minute there's a missed call. There's no possible way under the sun you don't recall if you called him. When you called them, do you know how much effort it takes to call someone that many times? You didn't forget. You intentionally lied to the court. On top of that, that timeline was provided to the prosecution, and the prosecution could have looked at the timeline and said there's no possible way that he was in her house, or no reasonable person to believe that he's in her house at midnight or between the hours of 11 and midnight, because she's blowing his phone up the entire time during that time frame. Doesn't make any sense.
Oh, wow. Oh, prosecutor, for fuck's sake, you have to have known this. This was turned over to you, and you still chose to go forward with this case. And now you are forever remembered on the interwebs as the prosecutor who believed a woman who lied.
And then she alleges she gets home, she had just gotten home from being with her friends, and then her phone was dead. But that's not the truth, because your phone wasn't dead because you blew it up. You blew up his phone using your phone. And then I see evidence where you're driving past the house that he's living in the middle of the night. The timestamp tells me 2:36. Multiple times you're driving by, glaring on the horn. There's a voicemail on or around that same time frame where she's upset about something. She believes that he's laid up with someone else. It's evident based on this that there's still some kind of relationship that was going on at that time. If she believes, based on the questions that was asked on the cross-examination of the defendant, that he provided or gave her an STD, they're obviously must have been still engaging in some kind of intercourse at the time. Nonetheless, she, during the date of the 26th or 27th, believed that he was lying about being at work. He's not answering her phone calls, and she believed he was with someone else, and that's why she's blowing his phone up. And she's going by his house at 2:30, 2:37, 2:40, up to 18 minutes before she allegedly called the police. She's engaging him by way of phone calls, repeated phone calls, and driving past the house, which is noted on video. I should also note that I revoked his bond based on an allegation that she made that he was driving past her house and that she has a video camera. I didn't see any video today that showed me that he broke into her house. But she obviously had video when it came time to get him arrested based on the allegation that the people can now not sustain. The people can't sustain any of this because it's contrary to the evidence that was turned over to them by the defense, and the people had a responsibility to dismiss this case.
Yeah.
And not waste the court's time. The timeline was clear. Multiple phone calls. There's zero question about her credibility. She lied to the court. She has maliciously prosecuted this person based on this lie. And I hope he takes recourse based on that. The case is dismissed.
No, the defendant is still on bond for a case set for trial in this court on April 14th against the same victim.
I can imagine.
Wow. Wow. Who is this judge? Who is this judge? I need more. I need more. Now, this is from the Court of Public Opinion.
I've never seen my daughter act like that before.
Oh, okay. So this is the Court of Public Opinion was the one who about 2 hours ago went in and tried to link to their channel. Yeah, I would say go subscribe to the Court of Public Opinion. I'm putting the link in here. Oh, Dave says he knows the judge. Dave, where are you? Dave. Okay, so Dave, yeah, this was a Michigan case. I have no clue who this person is or judge is. Oh, Dave had to leave. Okay. I mean, folks, I'm going to, I'm having fun. Let's do another one. Let's do another one. But I usually take something that is a bit older because I know that I don't want to take a recent thing from a channel because that is on their channel and they are currently getting views from it. So I would rather get an older case that I haven't seen Oh, this was good. This was good. Let's see here. Dun dun dun. Insane Karen held in contempt. Yep.
Yep.
All right, so we are on record in the matter of.
Hold up. Before I put this on, Jesus Christ. Do I need anything? I have nicotine pouches. I'm running out of whiskey here. But surely, yeah, this is fun. This is fun. Everybody go subscribe to the Court of Public Opinions. Because this was fun. Now, usually I stream the entirety of Judge Boyd's court docket or the entirety of George McBurney's docket or other. But this is clips of interesting stuff that has happened. Occasionally, my streams with judges is just the day-to-day things. So this is apparently, oh, this is fun. Oh. So, let's check this. Insane Karen in contempt after giving the lawyer the bird and accusing the judge of being a swinger. Oh, I can't wait. But first, let's have a one of these. Let's have one of these. Where is it? Where is it? There. Yep. The Norwegian fire-farting dragon. You cannot sneak up on that from behind.
William Branson versus Heather Collins, 2402269. And counsel?
Good afternoon.
Appearance, please.
Good afternoon, Your Honor. Highly Deborah agreeing to have Mr. Collins, Mr. Branson, who sits to my left.
Okay. And ma'am, your name, please.
Heather Collins.
Okay. So today is the date for the bench trial in this matter. And I see that there are other individuals here as well. So counsel, who else do you have with you?
This is my client's wife, Your Honor, who sits behind me.
Okay, will she be testifying?
Probably, yes.
Okay. And ma'am, who do you have with you?
I have Brian Loves, who's on my witness list.
Okay, so he may be testifying. So we're going to have those individuals that are set to testify go to sit out in the lobby so that we have clean testimony when it's time for testimony.
Mr. Branson is also on my witness list.
I understand, but he's the list of plaintiffs, so he would remain.
Okay.
Actually, Your Honor, Ms. Branson is also a plaintiff in this case.
I'm only showing Mr. Branson, so let me.
Oh, maybe you're right, I'm wrong. My apologies.
Well, let me just see.
Just so you know, these cases I will cut out the separate videos in order. If you want to go back, but you don't remember, oh, what was that? But I remember the case, but not the stream. I will cut these segments out to different videos, so you can go back and watch the thing that interests you the most. Okay, let's continue.
Here, because I'm only showing one plaintiff listed, so let me.
She's on my witness list, Your Honor.
I'm sorry?
She's on my witness list.
Okay.
It's August 8th with our heading numbers.
Right,
So
so I'm
that
only
is-
showing William Branson and
That's
Heather Collins.
correct. You're correct, no.
Okay. And so counsel, when did you file your appearance?
I believe we filed our appearance and our exhibit list on January 31st, 2025, when we were retained.
I wanted to state one thing is that my court officer informed me that he knows your client, counsel. I didn't inquire as to how he knows him, but I will say that I don't believe that affects my ability to be unbiased. But I wanted to place it on record in case anybody had any questions that they wanted to ask, or if they wanted this court to disqualify itself.
I do. If I might want this to be brought down to Wayne County,
What would be Wayne County? It would be another district court.
then yes, it might be. If it's not gonna be dismissed off of the motion to dismiss, then I do want it brought to a different court.
Okay, on what basis, ma'am?
I already know
Oh, she's representing herself. There's no lawyer there. Oh crap.
he's told me in the past that he has the judge in his pocket and the police officers in his pocket. I have a box of text messages saying that to me.
Okay, so let me just clarify one thing. Sir, do I know you?
No, ma'am.
He's been in front of you many times and I have.
Hold on,
recollection of that.
ma'am, hold on just a moment. You made an allegation, so I want to clarify that for the record, because I don't know that I know Mr. Branson.
Yes.
I thought you was pointing at me, Your Honor. I didn't thought you was pointing Mr. Branson.
No, Mr. Branson.
Okay, so, sir, have you been in front of the court before?
No, ma'am.
Have you been in front of this court before?
Yes, I'm gonna say 20-some years ago.
So it would not have been in front of me.
No.
It was not in front of me.
Yeah.
When you were a member of the city council.
Oh, this is going amazingly from the start. She's accusing the court of being biased because she has text from somebody who says, I have this person in my pocket. Oh, that's not a great start.
I am a member of the city council?
You signed off papers on him to do side work and he actually submitted that and you were the one who signed off for him to do property work on his house.
Property work?
Yes, he actually submitted that in his own evidence.
That I signed off for him to do maintenance on his?
Yes, Your Honor. I have copies of the paperwork.
Okay, let me take a look at that paperwork, because, I mean, if I'm, and Mr. Branson, how do you know my court officer?
A longtime family friend from years ago. I haven't had any
I'll see the sample right there.
15.
Okay, so you know who each other, you know who each one is, but you haven't had any communication in the last 15 years?
No, easy, yeah, no.
If you wrote in his filing that he submitted.
Ma'am, please stop, just one moment, okay? All right. Let me take a look at that, please.
Oh, this is not going well.
Okay, so ma'am, this is zoning board of appeals and adjustment. I do not sit on this board. This is my husband who sits on this board. And I can 100% tell you that we do not discuss anything that he does here. This is definitely not me. I've never sat on a board, zoning and appeals board. And this is from 2009, so I can tell you 100% that whatever this would have been, I have no idea. And I will also state that member DeSanto abstained. There were two members one that abstained, one that was absent. So I don't know why he would have abstained. I have no idea, but I can tell you that I did not sign off on anything.
Your Honor, I'm just going off of what he used to tell me and then the text messages I have where he said I have the judge in my back pocket.
Okay.
Your Honor, again.
Let me,
That's not.
hold on, let me clarify something. Sir, do you know my husband?
Personally, no.
Okay. So ma'am, I will tell you right now, I do not know Mr. Branson.
Okay. Yes, okay.
So do you have any issues with this court continuing?
Not at this moment.
At least this pro se defendant. All right, fucked up. Let's hope for the best.
Okay, well, I would say that, that if something different comes up and it's shown that somehow I know Mr. Branson or somehow, then perhaps we can revisit it, but at this point, I find that I can be unbiased.
Thank you.
And I don't know Mr. Branson, and Mr. Branson knows, my court officer, but they haven't had contact for at least 15 years.
Thank you, Your Honor.
So.
I appreciate that, Your Honor, for you being honest.
Okay, so and I will also say too, in smaller towns, right, you're gonna have that crossing and such, but, you know, as I learned in new judge school, that judges are elected to serve, and they have to sit and reside in the community that they serve, and so sometimes there's going to be people that they know, so it all just has to be disclosed on the record.
May I just be frank a moment? I'm just scared because in my text messages, since I've lived there, he has said he has police officers in his pocket. He has a judge in his pocket. That is just where
let me see the text message you're referencing.
No, I will find it. I have 2 full boxes that I've printed out.
Okay, I'd like to see that.
I will have to find them. But
okay, I'll give you a moment. Go ahead.
Oh, she made claims. And now the judge says, okay, let's see where he claims that. Uh-oh. Oh, this is going to be amazing. Thank you so much to the court of public opinion.
I don't know if it's in these, I can pull them up off my phone too, if it's not in the ones I printed off here, it might be in the ones that I gave you.
Okay, you said gave me, and you're filing that, the motion?
Yeah, I didn't print off all, the entire text chain, but the police also had them too, because we found out he wasn't a police officer. That he's never been a police officer, that he's told me, but we could continue, that's neither here nor there.
Actually, no, Your Honor, she said she just represented under oath to the court. She made a statement, an affirmative statement about.
I just wish she
You can't interrupt. Okay, just one moment.
At this point in time, Your Honor, she's sworn under oath, and you've asked her for those documents, now she's backing away from it.
Oh, no, no, we're not stopping. I need those, I want to see.
Okay, I'm trying to find them right now, I have stage 4 cancer, I had a surgery, Your Honor, I'm saying if I don't have them.
Oh, pro se people. If you claim to have something, you better have it. Oh, I have had cancer. I had surgery. I'm hoping you are recovering. But if you don't have it, then you lied.
Yeah, they're on my phone.
Okay,
I like time. If I can't
I'm
find-
giving you some time right now to look for those.
I have over 1,000 pages here. I'm just saying.
Okay, then do you have your phone with you?
Yes.
Okay, pull up your phone, and then on your text messages, when you pull it
May I
up.
sit down a moment?
Absolutely, then you can do a
Yes,
search,
thank you.
absolutely. You can do a search for the name Pocket, or search.
I don't know how to do all that, ma'am. I have a 2010, I mean, an iPhone 10.
Actually, you can
Oh,
just go to you can go to your text messages, you can hit search, and you can just type in a word, and it'll pull up all text messages that have that word in
The
it.
police are going through my phone because he has gotten into my phone, Your Honor. The police have, I have a police case against him right
Hold on,
now.
yeah, right now, I'm not worried about that. I want to know what that says.
He's been editing my phone, Your Honor, is what I'm trying to tell you.
Yeah, please just,
he's been editing my phone. Oh, God.
take a minute, or 2, or 5, and look for that, please.
I will. But I'm just saying, I
I don't
also
know,
motion to dismiss.
no more commentary, with no more commentary.
My motion to dismiss, what do you mean, I think?
I said no more commentary. I haven't gotten that far yet. You've made an allegation, and I want to see what that message is. And did you do a search?
I am looking right now. It won't let me do a search. So I have to look through the entire text feed.
Do you know what month it was that he stated that to you?
When I first moved in,
Which was when?
back in June.
Okay, so
That's
just
why-
going back to June?
Yeah, that's why I've been terrified living there.
Okay, ma'am, I didn't ask for all that. I'm just asking if you went back to June.
Yes, I'm all the way at the beginning of the text feed. That's why I said we can move on. I'm fine.
No, ma'am, we're not moving on until I see that. Did you find it yet, ma'am?
No, ma'am, I'm still looking through all his comments he was sending me. Your Honor, there's honestly gonna be a moment. I might have misspoken, he might have said it to me. And he was telling me that he was a police officer and then turned to city work because it paid more. And honestly, I'm not trying to lie to this court. It was said to me.
You made an allegation, and it's on the record, and so I would like
It
to.
is on the record 'cause it was said.
Ma'am, I'm gonna let you know right now. I'm not gonna have the continued interruptions. You made the comment on the record, the allegation on the record, so I want to address that on the record. That is what I'm saying. Because I can assure you that in the event anything like that was said, this court's not in the back pocket of anybody. I don't even know the plaintiff, as was already established. Okay, well, while you're still looking for that, I'm going to ask a few questions. Ma'am, you have been residing in the home since June, correct?
Correct, Your Honor.
Okay. And what is the monthly rental amount?
$1,500.
And counsel, what is the tribal issue that we have?
Your Honor, there is a tribal issue. She's just admitted the amount of rent. What's left is in terms of what's owed. The last time any rent was paid, and we provided this court with a ledger, and I believe that amount is within the ledger. And it's my understanding that there was a partial payment of rent for November, $500, with a balance of $1,000. The December, January, February rent were not paid in the money. This court had.
I'm sorry, November, December, January?
There was a $500 balance in November.
Oh, November, okay, I'm
Yes,
sorry.
ma'am.
$500 partial paid with a $1,000 balance in November. You
That's
said
right.
December and January and February, you've not been paid?
Have not been paid, but I verified earlier today, per the court's order, she had made $5,500 deposit into the escrow.
Correct.
Notwithstanding that, Judge, there's also, as of January 30th, there's a gas bill, which was paid by my client, amount of $326.68.
Hold on, have you supplied Ms. Collins a copy of the gas bill?
I believe. No, Your Honor, but we can print it, I apologize.
Well, okay,
It's something that just came up like the last day or two.
okay,
You looked it
well,
up the last day or two.
hold on a moment. if you filed an action, let me see here. The complaint alleges,
My client filed a charge complaint period, and the complaint does allege that, the rent is what it is. And there's also, I know.
hold on, counsel, hold on,
Yes,
please.
ma'am.
It takes me a minute to get to it because I have to click on a bunch of buttons. So it's showing that $2,500 a month was due as of December 30th.
That's right.
$625 in other fees, and those are late fees. Sir, how much are the late fees per month?
How much is it? No, Your Honor, these were not late fees, it's a mistake.
Counsel, I'm saying what's on the complaint. It says other money is due, $625 and it says late fees and due by December 1st of 2024. So what is the monthly late fee?
I did not do, I didn't do like monthly, in the lease it said $25 a day, not understanding that it couldn't do that and not worry about late fees.
Oh, yeah, no, this
Yeah,
one, absolutely
I
not.
missed, yeah, I totally misread that.
We withdraw the allegation.
Okay, so $625 was not due.
Yeah, no, we were not expecting that. We weren't expecting that.
Okay.
Once I was told that, no, you can't do that.
Okay, so then the only thing that you were looking for was the rent that was not paid.
Correct.
And so,
And utilities.
well, hold on.
All of this for unpaid rent. All of this for unpaid rent. Oh God.
Hold on, that's not on the complaint. On the complaint, it says $625 and it says late fees. So you're withdrawing your late fees.
Correct.
Okay, so it doesn't have any other allegation in here other than the unpaid rent.
That's correct, Your Honor. We will withdraw the allegations regarding the utilities. So the only thing we're seeking, in fact, are the rent, just the rent.
Okay, now, December and $1,500, so that's $5,500, so $5,500 is due and owing, and Ms. Collins has deposited $5,500 in escrow.
Correct.
So once your client does that, rent's paid in full.
That's correct.
Okay, so Ms. Collins, you filed two motions. So I was actually asking those questions because I wanted us all to be on the same page with what the issues are. So you filed a motion to dismiss and an amended motion to dismiss, and then you've also filed the motion to suppress the exhibit list. Now, I will note that this matter was scheduled for today, and that these show that these were filed on Wednesday. Well, one was filed January 31st, which was the motion to dismiss. The amended motion to dismiss was filed February 5th, and then the motion to suppress the exhibit list was filed February 6th. Those weren't filed timely to be heard today with the court, because there needs to be proper notice, whether not only to the court, but also to Mr. Dagger.
You got it.
I'm sorry.
It goes both ways.
And so when you made the comment, ma'am, that your motion must not mean anything, that's not accurate. We can set it for a motion hearing later on, as far, it has to be filed at least 7 to 10 days prior to the hearing, depending on how it's being filed, okay? So, but it appears as though the rent has been paid in full, so what is the issue?
Your Honor, he doesn't have a certificate of compliance by law, and Wyandotte law, he cannot collect rent there.
Okay.
I haven't paid.
Hold on, just a moment. So before the court determines if it's going to release the escrow money to your client, do you have a valid certificate of occupancy, sir?
Currently, no.
No. Okay.
And the reason he doesn't have it, Your Honor, is because he's attempted to obtain it over the past few months.
Hold on, I'm gonna get to you, ma'am.
And we went back and forth. In order for it to be scheduled, you've got to be able to specify time and date for the inspection to occur.
Okay.
She's refused to allow the inspections to occur, insisting through text message that no one can appear after 2 p.m. The city of, I believe that's what the text message says, I could be wrong. Nevertheless, she's been a hindrance to allowing it to happen. Notwithstanding that, Your Honor, this issue of certificate of occupancy has never been raised before until after the eviction's begun. And as such, it's sort of a mood issue. Notwithstanding that the law, unlike what she claims, does allow the rent to be collected. And it's a question of fact for the court whether or not the place is habitable. The issue of rent abatement is really directly habitability.
Hold on, just a moment. I'm not necessarily talking about abatement.
Yes.
But I believe, if my memory serves me correctly, if somebody has a temporary C of O, they can collect rent. If they don't have a C of O, they cannot collect rent, is what I recall. Nevertheless, ma'am, has there been attempts and this is a yes or no answer. Have there been attempts to schedule an inspection with the City of Wyandotte Building Department?
No.
Okay. Mr. Branson, and council, I'm not trying to cut you out of this, but
No, I'm glad you're doing it. You're doing a better job than I would.
Mr. Branson, do you have any communication from the City of Wyandotte that has attempted to schedule an inspection?
Verbally.
I do not need any comments, ma'am.
Thank you.
I'm talking to you.
Sorry.
Verbally, I talked to Callie at the engineering office and basically she said, you have to give me a date so we can get you scheduled. That's what it was. And then I tried.
Hold on, a date for what? A date after all the repairs have been done?
No, a date to get the inspection done. She says, I need a date, so, I can pay and give them a date, we can follow through.
Okay,
Knowing she had health issues and things, I tried to communicate with her, starting back in December, saying, when's a good time to get in?
okay.
Yes.
Pause on that. Who has proof of those communications? I'm gonna guess you do since you have 2 boxes of text messages, correct? Okay, I'd like to see the communication between you and Mr. Branson regarding scheduling for the inspection.
I have something better.
Hold on, first I want to see those text messages.
He never went to the city back in December.
Okay, first let me just see the text messages, please.
I can show you my phone.
No, you said you printed them off.
Yeah.
Okay,
I said if somebody was in my house, he could come over. He then never wanted to come over.
yeah, right now I just want to see the text messages, please.
But it wasn't for the city, never once for the city.
Ma'am, please.
Your Honor, while she's researching it, may I add something about the law?
No,
Oh,
just a moment.
yes, ma'am.
Man, these are out of order, the December ones are not.
Okay, is that your phone?
Yes, I'm gonna pull them up. December 23rd, he
Okay,
said,
no, I'll take a look at your phone, please. You can show council and then.
This is why you do not go pro se. Have everything in order. Everything.
And, council, I'm gonna look at that message there.
Your Honor, I'd like to see the before and after conversation.
Okay, well, first I want you to look at the December 23rd.
Mhm.
So, ma'am, if you can show Mr. Dagger the December 23rd message.
this is, I'm just touching my phone.
Council, you can just look at the phone.
Yes, I can't read it very well. Thank you.
This is from him.
This is from him, okay. Can I see the private message, please?
This is from him on the 23rd.
Can I see the private message?
This is from him on the 20, okay.
First, no, stop. I'm not gonna have you arguing. I said right now, just the 23rd.
Thank you, Your Honor.
And then council, I'll review that and then I'll move from there.
So this is your message, Jamie?
No, this is your message from your
This is
person.
my client's message?
Yes.
Thank you. You're showing me what you want to show me.
No, I'm not.
Council, listen, I'm telling both of you right now.
I saw-
Stop. Right now, I said just show the 23rd, right there, that one message. And then I'm going to go from there, council. I'm very familiar with messages that are deleted, not deleted. There's things that go before and after. So right now, I just want to look at the 23rd that she found, and then I will go from there. I don't need any more commentary. Council, did you look at the 23rd?
Your Honor.
I'm still showing him the ones on the 23rd.
No, just the one. How many are there?
Well, there's my responses back to what he sent me
Hold on.
about that message.
I read my client's response. Your Honor.
No, that's all, I'm sending him the one he sent me about the inspection.
Okay, that's what I want to see. Let me see the 23rd.
And then I was gonna show my response.
After that, after I look at this one, then you can show the response.
And that's the first time he ever brought up an
I don't need
inspection.
any more talking right now, please. Okay, so on December 23rd, there is a message that reads, good morning, it's at 11:17 a.m. Good morning, due to a scheduling issue, we are postponing the filter change at 18:30, which I'm presuming that means at 6:30 p.m. On December 23rd, 24. We will change the filters during the city inspection that is scheduled for January. Time will be determined by the city, business hours is in parentheses. There will be 4 inspectors plus myself and must have access to all rooms and storage spaces, i.e. closets and pantries. We are sorry for the inconvenience and have a happy holidays. Now, I'm going to scroll down. I'm going to read the message right before that, which that's in green. So that is from Ms. Collins. Obviously, there would be a penalty because you're not willing to give me my security. So don't act like you're trying to be someone nice when you're not. Why are you bringing an officer into this when I told you I'm going to be having someone here? So stop it now. If you want to fight with someone, continue it with your wife. Leave me alone tonight. Prior to that is from your client. There's a matter of 4 messages. We won't be coming into the office yet here. And then next one, officer with the asterisk. I'll be testing the locks to ensure they work properly. I don't understand. This is such a horrible environment. Why you wouldn't want to leave, especially with the accusations you made. We are willing to break your lease, no penalty. Prior to that one, this is from Ms. Collins. No offer needed. I have someone coming. I'm not resending the list. I sent 1,000,000 times. I stated before. You said you saved all your messages. Relook through them. I'm not playing your games. I'm not sending another text message to you. I need to save my strength. I'm not sending another text message to you again. I will see you on Monday at 6:30. Goodbye. Do not come a second earlier. I will call the cops breaking in. Really? And it's
He can do whatever he wants
don't-
to. I'm
stop.
sorry,
And it's 6:30 PM, to be clear, because we both know how you twist things. Do not use key, I will open door, or I will change locks. Prior to that, and that was in response to the message from your client. Actually, I'm gonna go two back, I'm gonna go a few back. This is all still, okay, starting December 21st. Good morning, is there any this is from your client, counsel. Is there any possible way we can meet a mutual agreement that we can get into the house and change the furnace filter? Start up the humidifier on the furnace, change washing machine discharge filter, and check the GFI, the kitchen. No arguments, we don't even need to have a conversation. I just need to make sure everything is operating properly so you don't have a breakdown when it gets colder. It's an older home and there's no insulation in key walls. Kate and I will be coming in together so we can get out of your hair faster. I would like to do it either tomorrow or Monday evening after 4. Also, has the bathroom sink filter been cleaned? And Ms. Collins responds, it won't be until after 6:30 on Monday when I have someone with me. And the bathroom breaker needs to be fixed as well. If you're not willing to fix everything, then don't fix anything, clean and simple. There's more than just a problem on your list that needs to be done. And Mr. Branson responds, we will be there 6:30 on Monday. Thank you. I'll bring a GFI to replace the, if needed. And Ms. Collins responds, I said, only if I find someone to be here with me, please don't misread that. No, ma'am, you said when you have someone with you. Let me clarify. You said when you have someone, that's in your message. And then Mr. Branson says, please read your lease. Thank you. And then Ms. Collins says, I will not be alone in this place with either one of you. I don't care. I feel unsafe and my life is more important. Facts. Mr. Branson responds, them, you are refusing, correct? I'm giving you 48 hours notice for the record. Ms. Collins responds, I have you on tape saying you don't care if I feel unsafe. Conversation done. You are not allowed in unless someone is in here with me, so no, do not come in.
Uh-oh. Yeah.
To which your client responds, then have someone there with you. This is your written 48-hour notice. Ms. Collins responds, no, in all caps. Mr. Branson responds, thank you. Ms. Collins says, call the cops, I don't care anymore, in all caps. Mr. Branson says, all I needed. Ms. Collins says, I will put my safety before you, plain and simple. I feel unsafe around you. I feel in danger around you. The words I have on tape that you said that came out of your mouth is all I need. Okay, then there's some allegations I'm not going to read into the record because I don't know what basis that is or not. And then Mr. Branson states 6:30 Monday to get combinations done. Ms. Collins says, plus some of the stuff I paid ready to get fixed because you refuse to fix them that I've asked for months. Mr. Branson says, send me proof in the bill. Ms. Collins says, I will have every door locked. You will not be coming in at 6:30. Mr. Branson responds, I have keys. Ms. Collins states, just like you not sending me proof of bills, I don't need to send you anything. I will be seeing you in court. This will be my last message to you. Mr. Branson says, by law you do. I will be there with my key at 6:30. Just so you know, in your safety, I requested a civil standby with line out police at 6:30 on Monday. An officer will witness everything. Please send me a list of everything needed to be addressed and repaired so we can inspect and address. Also, bills for said repairs so we can inspect and address. Thank you. And then that's when the message that she said she's not resending a list a million times that she sent that. So what I haven't seen here, well, I see that Mr. Branson stated that he
I put one in.
was going to do the inspection in January. Then on December 30th, Mr. Branson says, good afternoon. We have not been in the 22-23 premises, the 2223 premises, nor changed any of your filters, which are now way past scheduled maintenance time periods. If said proof was the filter you pulled out of the trash this morning, that is the filter for my furnace and humidifier. I changed all filters at the same interval since both furnaces were installed at the same time. Since you are refusing us access to change the filters, we will be doing it in January during the city inspection. Have a safe and happy new year. Okay, so did you have an inspection scheduled for January, sir?
No, because I couldn't.
No, so it's no.
No.
Wow, so you're watching my every move. This is from Miss Collins. Why should you watch everything I do? That is beyond so creepy. I purposely only throw all my trash on Mondays ever since you told me you go through my trash way back the first month I moved in. Do you go through your trash?
The trash goes into a community bin, and I put the trash out, so all of our trash goes into one bin.
Yeah, I was asking Mr. Branson. I saw the filter in there, and yes, I went down and I looked at my filter, and I have a brand new filter in my furnace, brand new filter in my furnace. I'm gonna repeat, a brand new filter in my furnace, and that is beyond creepy that you watch me when I go outside. Stop, let me live. Okay, the property, do you all live on the same property?
Yes, ma'am. It's a duplex, Your Honor.
Oh, okay.
He lives in 2221, and she lives in 2223, right next door. It's the same, it's a duplex with first floor and second floor in each unit.
Okay.
With a common basement.
Okay, and so ma'am, you've been residing there since June, correct?
Yes.
And so if you're having all these issues, ma'am, why do you want to stay there?
I don't. I've been wanting to move.
And here comes the crocodile tears.
They won't give me my security deposit back. Back in November, they told me they were gonna raise my rent $400 a week. I had text messages.
Ma'am, what steps have you made to locate another place to live?
I have been looking at association. I could show messages of every single property I've gone to look at. But without money, because I have to pay rent here or not put it into the court. And they will not, I've asked for my security deposit back. They have offered for me to get out of my lease, but they say, we won't give you your security deposit back. Because that's me breaking my lease.
Your Honor, if I may,
Yes,
I happen to have been the attorney that evicted her from the
I'm
last.
sorry.
I happen
You
to be-
cannot bring that in because I won that case. I won that case.
Ma'am, stop interrupting.
Sorry, Your Honor.
But you're not sorry because you keep doing it.
Sorry.
Stop.
I was gonna address the issue of money. I happen to have been the attorney that evicted her from the last location
Where was that?
in Dearborn. It happened to have been, she went from Dearborn to here. She,
Stop right now. I will get to you, ma'am. Stop the antics.
we allowed the case to be dismissed because she apparently left and left us with about $11,000 bill.
No.
We haven't chased her, we haven't done anything to her, because frankly, my client don't want anything to do with it. The point of my telling you this is that indeed, the allegation of having money has been raised over and over again before.
Right. Yeah.
And as you know, Judge, if she leaves, right, she's obligated after a certain period of time to return the money. Otherwise, she can sue for double and treble damages. So what she's alleging simply doesn't make any sense. And as you can see through the text messaging, in fact, offer to say, leave and we'll terminate the lease. And in that, when the lease is terminated, an inspection is done. And at that point, whatever the balance is, we'll go back. Now, keep in mind that you didn't order anything to be deposited into the account until the last year, which was at the end of January, correct? And so that money was readily available for her to have left in December. So that.
Which I'm not following that, counsel, because I ordered an escrow order.
You did, and
And
she won't the money.
and she's been paying in the escrow order.
That's right, but you can see in the prior text messages you read, it showed that in fact had offered to terminate the lease in December. And they told her, if you don't want it, stay go. Had they terminated the lease in December, they would have gone through the process of giving her whatever the security deposit is under the law, right? And in fact, her allegation now that she has no money didn't make any sense because as soon as you ordered the escrow to be put in, to be set up, it was set up and all of a sudden the money's there. So I'm just pointing out the inconsistency in her statement.
I don't find that's really an inconsistency in the statement. Your client or Miss Collins found a way, I don't know, and in any event, the money was deposited for the court order.
Correct.
Because otherwise she would have been in violation of the court order. What is the security deposit amount?
$2,000.
Okay,
It was higher than that, Your Honor.
what was the security deposit amount then, ma'am?
The lease agreements speak to it.
I understand, she's claiming that it's a higher amount, so I'm just trying to figure
I
out.
believe it's a higher amount. I'm trying to pull it up right now. It was a month and a half. It was $2,225.
Okay, is that what was deposited?
I'm trying to locate her actual check.
Okay.
Your Honor, may I make a point?
Not yet. Okay, so I'll take a look at the check that he has.
Someone, can I show it to her first, sir? You mind handing it to her?
Well, you're gonna give it to the officer
I am.
and then my officer's gonna show her.
Yes, sir.
Ma'am, is this your check that you paid for the security deposit? Yes or no?
Yes, I was wrong, Your Honor, yes.
Okay, $1,500 check and then a $2,000 check.
The 1,500 was the first one.
Yes,
Which
I see
I'm
this.
disputing the first month.
Just one moment, ma'am. On May 25th, you deposited a check. It looks as though it says deposit for YNW, so the security deposit, $2,000. On May 25th, you also made a payment. It says rent first month, June, $1,500. So what is it you're disputing about the first month?
He had me paid to move in for June 1st, yet I wasn't allowed to move in until June 16th. Because supposedly they were gonna redo the kitchen. And I have, if you look at my phone, I have plenty of text messages where then finally in October, while in the hospital, they say, we really weren't gonna redo your kitchen. They baited and switched me to move in there.
While in the hospital?
Yes, I ended up.
They came to the hospital?
I ended up in the hospital for a month and a half because the basement is full of black mold, which they knew from the 2 pages from 2019 that that place cannot be lived in.
What do you say? She can have it back, please, thank you. What are you saying from 2019?
The city of Wyandotte said that that basement has a big crack in it and that it's contaminated with mold and it had to be fixed. They still, knowing I have stage 4 cancer, allowed me to move in there. I also with lupus. Within 2.5 months of moving in there, I got put into UMM hospital and I was in there for 2 months. They knew I was in there. I now have a rare disease that doesn't hold vitamins in my body and I've lost over 20 pounds since I've lived in that house. And they know this.
And now that I've got the copy of the 2019, the 2 pages, which also is most of the stuff I complained about that needed to be fixed since I've lived in that house. My doctors in U of M are testing my body compared to the samples we took from the basement to see if that's what's causing my body to do a complete shutdown. Because I ended up losing my sight, which I have messages to them because they were asking me to leave in October.
Hold on. So
While in the hospital, they asked me
your
about it. I lost my sight for 2 weeks while in the hospital.
Okay.
Because of the place I live in.
All right, so I think it's evident that Ms. Collins is going to be moving out. So, counsel, at this point, where do we go with whether or not your client's going to agree to return her security deposit, and then she's going to move out? And then we can indicate that'd be by February 28th. So that's.
I might need longer because I gotta find a place. I have stage 4 cancer, which I just had surgery.
Yeah, you said that you found a lot of places, but you don't have the money. So if you're getting your security deposit back, you have the money to pay for a security deposit, correct?
My next question would be.
But is that correct?
Yes, if I get it back before that, yes. The 28th, yes.
Okay.
Your Honor, we don't have a problem with giving the security deposit back. We would love for her to leave. That's not an issue at all. The only issue is we want to ensure that the damages, if any, okay, we would be allowed, if we were incurred the cost, to take it out of the security deposit, like we're allowed under the lease and we're allowed under the law. But the compromise here, we're willing to give $1,000 to her of the security deposit immediately to encourage her to leave. That's not a problem. And we would hold back $1,000. And then once she leaves and there's nothing wrong, if she gives us a 4-day address like was required by the law, we'd be more than happy to give it to her.
Okay, I think that's a reasonable resolution, yeah.
Your Honor, they do not have a legal lease. Here in 2021, they signed an affidavit with the city of Wyandotte that they legally will not rent the property or he will be served 90 days in jail.
You know,
Let me take a look at that, please. If you show counsel, please, Mr. Chairman.
He signed that with the city of Wyandotte.
Judge, if there's an answer for you.
Hold on,
We acknowledge
hold
the
on, let me review this, please.
I'm not living with a legal.
Ma'am, please stop, just one moment. Okay, that this is an affidavit of non-rental unit. It's top property address 2223, okay, and you're 2221. Okay, so counsel, after this, was there something that was put forth that your client does have a valid CFO for it to be a rental property?
What happened, Your Honor, is that when my client signed that, my client was actually living in that home while renovating the 2221. So when he signed it, that in fact is true. And then my client moved when he completed the renovation and began, am I wrong on this? We began the renovation of 2223 as well. Correct. And that's how this affidavit came to be.
Okay, so is there a subsequent affidavit from 2022?
No.
When did you start renting it out again?
She's the first tenant.
Okay, ma'am, you're saying, so I'm guessing that means no. So who was the tenant before you?
I got mail from, and there's a text message I can show you where mail was delivered in my mailbox from the tenant before me. And they said, oh, just put that in our mailbox because we'll forward it to them.
Who was the tenant before you?
I don't know the name, but I had gotten the mail because they told me, oh, the tenant had 2 children. She was a stay-at-home mom.
Yeah, but that doesn't tell me, that doesn't.
I don't
say-
know the name of the
Yeah.
tenant.
That doesn't say what year they lived.
Oh,
there.
they lived there right before me is what I was told when I moved in.
Who told you that?
Mr. Grayson and his wife.
That's a false statement, Your Honor. Mr. Ransom, what's the truth? You can hear directly from him.
But he also made.
Hold on, no, hold on.
We lived in the 2223. My parents previously owned the home. We lived in 2223. My sister lived in 2221. We then started renovations, which also, as you see from the sample issue, we had gone in front of the city to make all kinds of things in front of the zoning board to lengthen the driveway and do other things. That's why the renovations were done. Because we still lived in 2223 and 2221, basically, they just took it off the rolls because we were inhabiting both sides, if you will. No rent was being collected, nothing. We get mail from people still. I just got a voter registration card from Miss Becky Anwar, who lived in 84. I have that card sitting in mine. Yes, why not send a photo record for Mrs. Becky Anwar? We get mail all the time. My sister still gets mail and she's been out of there from time. She lives on Roseal.
Okay, so let me ask you this.
Yes, ma'am.
After you renovated 2221.
Yes.
And you moved out of the 2223.
Correct.
Then you were renovating 2223.
We were doing the updates and things like that.
Okay.
Yes, we did a
So after you were finished with that, what year was that?
that was probably around November of last year. And then the house.
23?
Yes.
Okay, so did you rent that out to anybody prior to Ms. Collins?
No.
After you finished with the upgrades?
No.
Okay.
You know, it just was almost like a storage thing because we don't have a garage. The city has made it difficult to put a garage for a divisional reason because we tore down the house on the corner of Second and Cedar. And there's no possible placement for a garage. So what I did is I took all the tools and hardware and everything and it was just stored in the living room and I used it like a storage place is what I did.
Okay.
Because it's connected, you know, to our house. It was essentially storage.
Okay. So. And you haven't been in the property since June?
When you say, you mean living there?
No, have you been, I'm sorry, I was not clear. Have you been inside of 2223 since Ms. Collins moved in?
Oh, no. Well, without her knowledge, no.
Okay. When is the last time that you were in the unit with her knowledge?
When she was in the hospital, she sent us a text that someone was moving through her house. I have that in text message.
That somebody was moving through her
Yeah,
house?
she said someone was on the camera. So I said, would you like me to go check? She was in the hospital. So I went into the house, said nothing's been arranged, nothing's been moved, everything looks fine. And that was the actual last time.
Okay, so when you were there, sir, did you notice that there was any damage to the property or anything of that nature that would be of significant expense after she moves out?
No, because I didn't really look. I was looking for a person, I wasn't.
Okay, but nothing jumped out.
Yeah, nothing jumped out.
Okay.
Yeah.
If I may just, supplement what he said. He called me yesterday, Mr. Ransom called me yesterday and said that the front door apparently was broken because the door was called door closer. The door closer wasn't working. So he did yesterday go in and repair the front door and repair the door closer so the door locked because it was slipping in the wind.
Okay.
He actually was in my house December 1st. I have it on videotape. You have the phone in your hand?
No, we had to give the phone back to you.
Oh, okay. I actually have the whole video of him and his wife in my house on December 1st. So, I mean, you'd like to see that.
Was he home on December 1st?
Yeah, he was shouting at me and told me I should feel unsafe and he'll come in whenever he wants, when I'm not there or when I'm there. I had it on tape, December 1st, so he just lied under oath on that. But you can see the videotape if
With
you
all due
like.
respect, Your Honor, the only person that's lied under oath is.
Would you like to see the tape? Would you like to see the tape that he just did lie under oath to, that he was in my house on December
Well,
1st?
I think that I asked, was there a time that, or when was the last time you were in there with her present?
Yeah, I was present on December 1st.
Yeah. And he talked about the time that you were in the hospital. We haven't really finished the rest of everything.
Yeah.
So the reason I asked that is I wanted to see if there was any way that your client was able to ascertain if there were any significant damages that would cost, obviously a significant amount of money upon Ms. Collins relocating. That's why I was asking that question, ma'am. So that was the sole purpose of this court asking that question.
My client is so tired of this, Your Honor, that's the reason we made the offer of giving her half, just being blind about it. We just want her out.
So ma'am, that seems as though that's a reasonable resolution.
No, Your Honor, I'm asking for all my money back because this is an invalid lease, because also I have two
Okay,
papers.
show me the law that says that it's an invalid lease.
I already submitted that with one of my things saying in the city of Wyandotte, you cannot have a rental property and collect any money. And that's included in my amended motion, where I gave that to you. But here he has with the city of Wyandotte, the reason why he does not want to get an updated one is he has 2 pages of violations that he occurred with the city on my property.
Have you rectified all of the issues that were listed? I don't see how that means.
2 pages.
I don't know what the 2 pages of.
They gave him a copy on January 7th, a recopy. They have one new.
Hold on. First of all, when one is talking, ma'am, you can't interrupt. Okay, and counsel, you can't interrupt when 2 people are talking, because then we have an even worse record. But what is it? Let me see what that is, please, that you're looking at.
They also sent him another copy on January 7th of the 2 pages.
Your Honor, first of all, I object to the document because it's clearly hearsay.
I'm just looking to see what it is.
Yes.
On January 7th. Okay. So, sir, did you receive a letter from the city of Wyandotte regarding a communication from the Department of Engineering and Building?
Yes.
Okay. So that seems to be the 2 pages that she's referencing. Well, hold on. She's referencing. Okay, so I'm going to presume that, is that when did you contact the engineering department to schedule the January date?
I've been in contact since December.
Put your hand down.
With Kelly from engineering, and I knew what it was is once we were out of there and I rented, it was like, I had made a phone call over there and said, do I need a certificate of occupancy? They said, there was a miscommunication, and she goes, no, you're 2223 and 2221, and they got them crossed over. She goes, no, you don't need a CFO. Well, later I learned, oh, you do. So I immediately started contacting. So
okay. So my question is, there's a whole bunch of stuff for 2223 on here. Have you made those changes?
I don't know what inspection is because it has had previous inspections.
Right, it's been from 2019. Here's what I have to do right now. Right now I have to, for safety purposes, I have to handle this in custody right now. So what I'm going to do is I'm going to order that you all go out into the lobby And ma'am, let me just tell you where I'm heading with this. That you've indicated you want to relocate. Mr. Branson has offered to guarantee, stop telling me, has offered to guarantee at least $1,000 back on your security deposit. And the balance of that upon your relocation is presuming that there isn't any significant damage, okay? So that is what is being offered at this point.
I want my 5,000 that's in with the court.
And I want the winning lottery numbers, but I don't have that either.
He doesn't have a legal right to that.
Yeah, just one moment. So I want you to go out in the lobby, you can leave your stuff right there, and I want you to process that and think about it, because right now I don't know that I'm refunding you $5,000, because I don't know that I have all the information. So I want you to process that while I handle this in custody, and there will not be any argument out there in the lobby.
You want us to leave this going on?
Whatever you choose to do, I have to do this in custody here. You can sit here, you just can't talk, okay? And if you go out in the lobby, you can't talk to anybody.
Can I go get some water, Judge?
You certainly may. Okay, off the record on this matter. Now you tell me when you're ready. Okay,
For the record, Judge, I believe she's been recording this hearing. I just heard the recorder go off.
we're not on the record, but now we're going back on the record. Hold on just one moment. Hold on just one moment.
I
Hold
just
on.
overheard.
Both of you, please approach. We are back on the record in the matter of Branson versus Collins.
I just overheard the recording being turned off by the phone.
Ma'am, have you been recording these proceedings?
I didn't know I was not allowed to. I have stage 4 cancer and do not remember everything. I need to do stuff so I remember and download everything.
There's a.
I didn't know I'm not allowed to.
For the record, she has at least 3 phones on her.
No, I do not have 3 phones for the record.
2 phones, my apologies, 2 phones.
Ma'am, you are not to record court proceedings. There are transcripts that you can order if you have a question.
Your Honor, I didn't know this. I record everything with my doctor's visits, everything. Because in my mind, I have cancer brain. I don't
Okay,
remember
stop
everything.
right now. You're gonna leave both of your phones in here, turn them both off, completely off.
I did not know this. I record everything because I have cancer.
Then ma'am, you should provide to the court's attention that you wanted to record.
I did not know.
Stop.
I would
You
like
should
you to
have
accuse yourself,
you
but
should have
you're
brought-
acting to me.
Stop
I would like you to
interrupting.
accuse yourself. I'm putting that on the record.
Stop
I'm asking
interrupting
you to
the
accuse
court.
yourself.
I'm asking.
Even if this is streamed or YouTubed or anything, if you're a defendant and are aiming for recording the proceeding, you have to tell the court.
I have a problem with him knowing him.
I'm telling you to stop interrupting the court.
I'm asking this to be brought into another judge.
On what basis, ma'am?
Because he knows him. I have a problem with it.
No, you already said you didn't have a
I
problem.
did not.
You sure did. You said you had no
I'm
problem.
appealing this, by the way. You are acting right now.
Ma'am, the court is not acting anyway.
Yes.
Other than
I'm
in
a stage 4
reaction to
cancer patient and you're
Excuse
taking
me.
my humane rights away.
Excuse me. The only thing this court is doing is acting in complete
I would
shock.
like to know from
And
the
you're-
court that you're raising your voice at
Stop
me.
interrupting the court. The incredulous behavior that you've exhibited by recording
Do not dare say that
again,
to me.
you are interrupting me once again. You have been interrupting throughout these entire proceedings, whether it's been verbal, nonverbal, or with raising your hand and making gestures. Now, the fact that you have been recording these proceedings improperly is extremely problematic, ma'am. Extremely problematic. Are those phones completely off?
Yes, they are.
Please show them to my court officer.
He could keep them if you'd like to, until the court is over.
They're off. Okay, very good. All right, we are on the record. We're off the record now. We're on the record
I'm gonna go get some water.
in the matter of the state of Michigan versus Richard Cobb, 25176. And detective, your appearance for the record, please.
Detective Delphi Haskin, YNW Police Department.
All right, and please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give this matter the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, you may proceed on the warrant.
On February 5th, 2025 at 10:09 p.m., YNW police officers Steve Rowe and Staff McKiss were patrolling the area of 4th Street and Goddard Road when they observed a white 2008 Chevy Trailblazer. The vehicle had a cracked windshield, the license plate light was defective, and the driver, later identified as Richard Cobb, was not wearing his seatbelt. A traffic stop was initiated. Due to the suspicious behaviors of the driver and passenger during the traffic stop, YNW K-9 Officer Cox was requested. Cobb was advised of the process of the K-9 open air sniff. Cobb refused to turn off his vehicle for officers to safely complete the sniff. Cobb was argumentative and refused to follow direction. Officers gave Cobb several verbal commands to exit his vehicle, which he refused to do. When Officer Tigro attempted to extract Cobb from the vehicle, he grabbed onto the steering wheel and pulled away. Cobb was reaching around the vehicle when he was tased by Officer Stathakis. Officers removed Cobb from the vehicle, and he violently resisted officers' attempt to arrest him. Officers had to administer a short burst of 3s plus P to Cobb's face. Officer Tigro sustained minor injuries to his hands in the process of effecting the arrest. After Cobb was arrested, he was searched, and officers located an assortment of individually wrapped narcotics in his right pocket, including Adderall, alprazolam, crack, fentanyl, ecstasy, and cocaine. A MAPS report indicated Cobb had no valid prescriptions for these pills. Additionally, a stolen loaded black Taurus 9mm handgun was found between the driver's seat and the center console.
That's a
All right,
fast-paced testimony.
Find that the offenses charged were committed and that there's probable cause to believe the defendant committed those offenses. And counsel, your appearance, please.
Good afternoon, Judge. Attorney Corey Westmoreland appearing on behalf of Mr. Cobb.
All right, good afternoon. And Mr. Cobb?
Good morning.
Good morning. Your name for the record, please.
Richard Cobb, Junior.
Okay,
All right,
now we have
and
a
counsel, as
completely different
to
case
the
in the middle of it. Why not?
arraignment on 13 counts.
Yes, Your Honor, I did have an opportunity to speak to Mr. Cobb regarding all of charges, his rights, and the maximum penalties. We are prepared at this time to waive a formal reading. My client stands mute.
All right, the court will waive the formal reading. Sir, you have the right to have an attorney. If you cannot afford one, the court will appoint you to represent you. And in fact, you've had an opportunity to speak to an attorney today, correct?
Yes.
All right.
Okay, and Gigi says I can fast forward. Okay, let's fast forward.
I just need to be able to defend myself. Bring up the right manners and manner. And show why this is illegal.
Your Honor, I apologize for.
Hold on, please. Hold on.
Shall he win?
Please stop talking. Okay, so we are back on the record in the matter of William Branson and Heather Collins, 240-2269. So, two things. One, I'm going to adjust the recording in just one moment. However, counsel alleged while I was on the record in another matter that Miss Collins flipped him off, gave him the middle finger.
Uh-oh.
Ma'am, I'm going to ask you one time. Did you do that?
Yes.
To Mr. Digger?
Yes.
Why?
Because I can't deal with his lies. He lies. He lies to what happened in Dearborn.
Ma'am, I was on the record in another matter.
I apologize to your court. I
Please
should have done it.
Please stop interrupting the court. I think I've run out of fingers how many times I've said that to you. I was on the record in another matter. Nothing was even being handled in your matter. You were sitting there and you just flipped off the attorney. So when I indicated previously that your behavior was incredulous today, that goes right in there to support that. Now, as it relates to the recording, Michigan Court Rule 8.115, sub 3, photography and audio or video recording, broadcasting or live streaming. That's the title of that. Except for requests for film or electronic media coverage of court proceedings as permitted under Administrative Order number 1989-1, the following restrictions apply to photography, audio recording, video recording, broadcasting or live streaming in a courthouse. A, in a courtroom. In a courtroom, no one may use a portable electronic device to take photographs or for audio or video recording, broadcasting or live streaming unless that use is specifically allowed by the judge presiding over that courtroom. The court did not give you permission for that because you did not ask. You did not ask. Paragraph 7, violations of this rule. If these rules are violated, the presiding judge may confiscate the device for the remainder of the day or order that the phone be turned off and put away. Violations of this rule are punishable by appropriate sanctions up to and including contempt of court as determined in the discretion of the court. Well, I can confiscate the device, but we're already at the end of the day. I ordered you to turn off the phone and still off on the table there. The court is going to find you in contempt of court for that very, very blatant violation, and the court is going to assess sanctions.
Uh-oh.
Now, you've had an opportunity, ma'am, to process the offer that's been put forth by Mr. Branson, correct?
Am I allowed to speak on it?
Yes or no? You've had time to process that.
Yes.
And are you going to accept that offer at this time? Yes or no?
No.
Okay.
I'd like to continue to live there then.
Here's what, I'm sorry?
If I'm gonna pay if you're gonna make me pay my rent then I'm gonna live there till the end of my lease, because this is not a legal lease.
You don't want to live there, you stated, and now you say that you're going to live there until the end of your lease because it's not a legal lease.
You won't let me defend myself. This isn't supposed to be a hearing where I'm allowed to defend myself, ask witnesses, and you're not allowing me to do any of that.
Yeah.
This has not been a trial whatsoever. This has been you controlling this entire thing. I'm not allowed to ask a witness anything. I'm not allowed to show paperwork to prove that he has other properties to know he needs certificates of occupancy.
Okay, again, let me respond to a couple of those things. Number one, you're correct. I am controlling the proceedings. That is my job as the judge, to control the proceedings. Also, it is my job to make sure that the proceedings are relevant and that we are not going outside of the purview as to what the issue is, okay? So the issue originally was unpaid rent. That rent has been paid. It's in the court escrow account. You have raised the issue of not having a valid C of O. It's been determined there's not a valid C of O. So what I'm going to do is I'm going to order two things. Number one, I'm going to order both parties to brief the court on the issue of the legality of a lease when there's not a valid C of O. That's the first thing. And those briefs are due on February 14th. That's in 1 week. Second, there is going to be an opportunity for Mr. Branson to inspect the property to see what current status it is in. Okay? Now, when I say that, then he can have somebody present that's not his wife. You can have somebody present. And I'm going to pick the time right now before you leave. And that's what's going to happen. Yes.
May I ask that he not videotape all of my possessions while he was in there? Because that's what he wants to do.
Yeah. If there is an area that needs attention, such as something that's broken,
yes,
something that needs to be repaired,
yes,
something of that nature, he absolutely has the right
100%.
to take a photo.
Yes,
okay,
100%.
No videos, take a photo. Okay, now, what is everybody? Let's see, everybody's available tomorrow? Yes.
Can I ask a question?
Yes.
He would take a video of a photo of what's wrong, but I think he also has a right to take a video or a photo of the entire space to demonstrate that as of that time, there was nothing wrong with that space. So that in case something happens between tomorrow, wherever he designated time, to the time she vacates.
No.
Ma'am, please stop interrupting.
And that way we will feel assured that in fact, we have a complete accurate picture of, we're looking for the walls, looking for plumbing, we're looking for flooring. That's it.
I hear you, counsel. And if there isn't an issue, then your client won't need to take a picture of it. So in my thought process, if there's an issue that has to be taken care of, he's going to take a photo of it. If a wall isn't damaged, then there won't be a photo of that wall because it's not damaged. And if it's subsequently damaged, then we know that something happened between the date that they're there inspecting it and the date that the hole's there. Okay?
Thank you.
So I understand what you're saying. And so my thought was this way, right? Ms. Collins can be assured that there's not pictures or videos of all of her possessions, and we're only focusing on what areas are in repair, need of repair or otherwise. And if they're not taking a photo of, and then subsequently they're, in need of repair, then there's an issue.
So let's put on the record with Ms. Collins that would state that he's only to take pictures of something wrong, and there's presumption that nothing is wrong if he doesn't take any pictures of it. We put that on the record.
Okay. Would you agree with that, ma'am?
Agree, but am I allowed to show him things that are wrong as well? And if he doesn't take a photo though, that doesn't mean it's not wrong. Because I don't want to show him areas that I know that are wrong and then he just doesn't take a picture of it.
If there are areas that you know that there are in need of repair, then Mr. Branson, I presume, would be taking a photo of it. So if you're shown that area, sir, even if you disagree that it doesn't need repair, take a photo, and then when you come back, we'll address it.
Yes,
okay?
Yes, sir.
So tomorrow, 12 o'clock, what are you both doing?
I am working.
What is your shift? What is your shift tomorrow?
I work 11:30 to 7. Both, I work that and then I work 11:30 until midnight on Sunday.
Where do you work?
At the VFW.
Which one is that?
The one right on 4th Street. On 4th Street in Wyandotte, right a few blocks from here.
Okay. Were you there last weekend? Okay, I don't know. I'm just gonna say I was there last weekend for a surprise party.
On Saturday?
Yes. but
Yes, I left at 6 o'clock.
Okay, so I was there after that. I just wanted to state that I was at the same location.
Yeah, I helped set it up. It was really cool. They have balloons and cupcakes, yeah.
But like you said, it's a very small city.
Okay, so,
Your Honor?
yes,
My apologies. Also tomorrow's difficult for me. I'm the supervisor for the Wayne County Road Commission and we have snow coming in and it's pertinent that I'm there to
you
support.
do?
Yes, we have up to an inch tomorrow.
He did a 30-hour shift.
I just got off a 30-hour shift for the ice storm.
Okay, what is your schedule on Monday?
I know I have one doctor's appointment. I don't remember what time, but I will make time on Monday.
Would your appointment be after 3 o'clock?
I believe not.
Okay, and what time do you get off of work, Mr. Branson?
I can be free all day. I can take the day off. Monday, I don't have any weather, so whatever's easiest for her to make this easiest to make this move.
And may I have somebody with me?
I already said, you can have somebody with you, and Mr. Branson can have somebody with you. That's not his wife.
That's correct.
So then there's not a question as to whether or not, you know, anyone's ganging up on anybody. So, Monday, February 10th, 5 p.m. Does that work for both of you?
Yes.
Yes, Your Honor.
Okay, now, I do not want to have everybody come back and say that it didn't happen because I didn't have anybody available. Find somebody. Find somebody. Whether it's somebody you work with, I don't know. Find somebody, whatever it may be. Okay, now, I'm also going to state as well that I am expecting the most civilized behavior that there can be. So ma'am, that means no mumbling under the breath comments, nothing. You can say, here's an area, and that's it. Not, here's an area that you failed to fix when I asked you to, or here's an area that's been like this since before I even moved in, nothing. No commentary, other than this wall, or this door, or this electrical switch, or this filter. That is it. Nothing over and above that. You are not to be recording at all.
What about my cameras that are already in my house?
That's a different story. They're already on, right?
He knows my cameras are there.
Again, ma'am, I just said.
I'm sorry.
You have a problem with not making comments. You're not to record on your phone, not to put your phone in his face, vice versa. Okay? And then I will have you both back on the 21st.
Your Honor, I have a question. May I take pictures too of what he takes pictures of?
Sure, go right ahead.
Just so I have the same.
Let him take the photo first, and then you take the photo.
Thank
So that then there's not an argument as to whose camera's in the way or whatever.
Thank you.
The 21st.
Judge, may I, about the 21st?
Yes.
I haven't taken a vacation in 3 years, and I'm really exhausted. I may leave town just for the weekend to go to Florida. Maybe could we do it on the 20th instead? Or
Well, that's our state day.
Or even 19th if it's possible.
The what?
19th.
Well, that's our, so the 19th and 20th are both very full days typically. We could do the 18th.
I take the super clear.
I mean, how dare you take a vacation?
The 18th, I work all day, sorry.
All day?
Yes.
What time do you start?
I'm the only one that works the day shift. I'm on Tuesdays.
Okay, what time does that start?
At 11:30.
Okay, so we can do 8:30 in the morning?
Yes.
In the meantime, Council and Ms. Collins, brief the issue of no C of O and what the effect is on a lease and collecting rent by next Friday, the 14th. Also, ma'am, please make a list of everywhere that you're applying for housing and see what all that detail is as well, okay?
I have to get the list into you.
You're just gonna keep a list and then you'll bring it on that day.
On the 14th, on the 18th.
Yes.
Your Honor, the legality I have to do a what?
A brief?
Just write why there has to.
Write what law you're referencing what law you're relying on, and the facts of this case and the effects, how that law applies to the facts of this case.
Okay, may I also make one more point that I've been trying to make this entire case?
Can you what?
Make one more point I've been trying to make this entire case. That he tries to say he didn't know that he had to have a CM.
Yeah, I'm not addressing that today. I'll address that on the 18th. Whether he knew or didn't know, quite frankly, is irrelevant. You're raising the issue that he is illegally collecting rent because he doesn't have a C of O at the property. So I'm having both you and Mr. Dagger brief the issue as to how that applies to this case and what the ramifications are if somebody's collecting rent without a C of O. So whether he knew or didn't know or claimed to know or didn't know, that right out in my mind is not relevant at this point. I want to see what you're both stating is the law and how that applies. And then you'll go from there. Maybe on the 18th, I'll want to hear that. Maybe it may be relevant. I don't know. But for right now, I'm not hearing any more testimony, any more arguments. That is what the court ordered. And you're all to return on the 18th at 8:30 p.m.
Will I be able to bring my witnesses up at that time too?
Yeah, let me just say this, okay? Neither side has presented witnesses today because this court has not found that it was necessary to hear the testimony from the witnesses at this point. Because I've heard testimony from both you and Mr. Branson as to what the issues are. Okay,
There's more issues.
Just one moment. And so for those reasons, the court didn't find that it was necessary today to hear from those witnesses. Perhaps on the 18th, I may need to hear from those witnesses. I'm not sure. What is the other issue?
That he had me move in and he made me pay rent for the first, because he said he was redoing the entire kitchen. I could move in until the 16th, and he's never redone that kitchen.
Hold on. So is your issue that the kitchen has?
Yeah, I'm going to let them argue on another day because it is 5 a.m. where I am. I'm at 4.5 hours. Was just supposed to do 2 hours. So folks, from the bottom of my heart, thank you. Thank you for allowing me to do this. Thank you for hitting the thumbs up and all the YouTube things. Thank you over at Rumble. Thank you to Slidy Pie, Ambrosia, and all the rest of you. Thank you guys over at X for staying with this stream for this long. I am going to send you over to the expert who is currently doing he's doing a Friday Night Live. But it's 5 a.m. where I am. So I need to get some Nana go sleepy. Okay. So everybody, thank you. And remember, folks, hug your family. Unless your family's shit, then screw them and give your love to the people who deserve it. And I see Brain Socks. Thank you for your $5 Rumble rant. Thank you so much. And I also have Kelly, $5 share to Friday, and Dave, $20. That says I'm going to bury something. Everybody, thank you. Saturday I might not do anything, but send me the stuff you want me to cover. And Sunday I might do a short stream or a couple of videos. Okay. Thank you. Have a good one, and I'll see you. Bye-bye.
storm.